If you've been watching my other videos about how the Employment Standards Act works in Ontario, you've probably noticed that there seems to be an endless mountain of rules, regulations, rights, and obligations that are imposed upon employers and employees. So it's possible that you might have wondered, by this point, how any of this stuff is actually enforced. Although most people know that you can go to court to enforce your rights, that's only one option available. And sometimes it might be the best option, and sometimes it might not be. This video isn't going to be about how employment lawsuits work in Ontario. Rather, we're going to talk about the enforcement mechanisms that are specifically described in the ESA. Before we dive in, remember, the ESA doesn't apply to every type of job. Be sure to watch our detailed video explaining which jobs fall outside its protections. Also, this video is for educational purposes only and does not constitute legal advice, and it is not intended to create a solicitor-client relationship. Okay, so what exactly does the law say about who can enforce the act, what they can do, how complaints are handled, and how enforcement is carried out? My name is Ryan Keeney, and I'm a lawyer in Ontario. Let's get into it. Enforcement of the ESA is regulated by Parts 21, 22, 23, 24, and 25 of the ESA, and these parts include Sections 84 to 139 of the ESA. Unlike my other videos, this video is going to focus on a substantially larger number of sections, stretching across the 5 parts of the ESA I just mentioned, rather than my usual approach of just talking about one part and a relatively small number of sections. The reason for this longer video is because these 5 parts of the ESA fundamentally accomplish the same goal of creating practical, real-life consequences to violating the Act. Although each part focuses on a different idea around the concept of enforcement, they function together to ensure that the law can effectively address situations where people have not complied with their legal obligations. Since the wording of these sections can unfortunately get super confusing, this video will explain each of these sections in simple terms, so anyone who is an employer or employee can easily understand the rules, assuming the job is regulated by the ESA. Because of the length of this video, I've placed timestamps in the description that let you skip ahead to the various parts and sections of the ESA depending on what you're looking to learn about. Although I recommend watching this whole video in context, I'm mindful of the overall length of time that would require. Our journey begins at Part 21 of the ESA, and this part includes Sections 84 to 95. It focuses specifically on who has the power to enforce the ESA and what exactly they can do. Starting with Sections 84 and 85, these establish the foundations of enforcement under the ESA. Section 84 states that the Minister of Labor is responsible for the administration of this act. This means that the minister has overall responsibility for how the ESA is implemented and enforced across Ontario. Subsection 1 of Section 85 goes on to explain that the minister appoints a person called the Director of Employment Standards to specifically administer the act and its regulations. Think of the director as the key figure responsible for making sure that the rules and regulations of the ESA are followed and enforced on a day-to-day basis. Subsections 2 and 3 of Section 85 deal with the scenario where the director is absent or unable to perform their duties. In such cases, an employee of the ministry can be appointed as an acting director. This ensures that there is always someone in charge of administering the ESA, maintaining continuous oversight and enforcement of the act. The acting director can be appointed by the director themselves, or if the director is unavailable, by the Deputy Minister of Labor. In essence, Sections 84 and 85 lay the groundwork for the administration and enforcement of the ESA, ensuring that there's always a clear chain of command and responsibility for upholding the standards set by the Act. Moving on to Sections 86 and 87 of the Ontario Employment Standards Act, we see the provisions related to the appointment and role of employment standards officers, as well as the delegation of the minister's powers and duties. At subsection 1 of Section 86, the law states that people necessary for enforcing the ESA and its regulations are appointed as employment standards officers. These officers are appointed under Part 3 of the Public Service of Ontario Act, which provides the framework for their appointment and the scope of their responsibilities. Subsection 2 of Section 86 mandates that every employment standards officer receives a certificate of appointment. This certificate, which bears the signature of the Deputy Minister of Labor or a facsimile of it, serves as formal recognition and authentication of their authority as an officer. Employment standards officers are thus empowered to enforce the ESA. They play a crucial role in ensuring that employers comply with the Act's requirements, and they have the authority to investigate, inspect, and take necessary actions to enforce compliance. Subsection 1 of Section 87 allows the minister to delegate any of their powers or duties under the ESA to any person in writing. However, this delegation can come with certain limitations or conditions, as specified in the written delegation. Subsection 2 of Section 87 clarifies that even if the minister delegates a power or duty to someone else, the minister still retains the ability to exercise that power or perform that duty themselves. This means that delegation does not strip the minister of their powers or duties under the Act. Sections 86 and 87 collectively ensure that there is a structured approach to enforcing the ESA. While employment standards officers carry out the day-to-day enforcement activities, the minister retains overarching control and can delegate specific responsibilities while still holding the ultimate authority under the Act. Moving on to Section 88 of the Ontario Employment Standards Act, this section outlines the powers and duties of the Director of Employment Standards, giving a comprehensive picture of the role they play in the administration of the Act. Subsection 1 of Section 88 states that the director has the authority to exercise all powers conferred upon them under the ESA and is responsible for performing all duties imposed upon them by the Act. This gives the director a significant role in overseeing and ensuring compliance with the ESA. Subsection 2 of Section 88 states that the director can establish policies regarding the interpretation, administration, and enforcement of the Act. This means they have the discretion to provide guidance on how the ESA should be understood and applied in various situations. Subsection 3 states that the director can authorize employment standards officers either orally or in writing to exercise certain powers or perform duties that are typically the responsibility of the director. This delegation is a crucial part of ensuring that the Act is enforced effectively. Subsection 4 states that even if the director delegates a power to an officer, they still retain the ability to exercise that power themselves. This ensures that the director maintains overall control and authority. Subsection 5 of Section 88 says that with the approval of the minister, the director can set the rates of interest and the method of calculating interest for amounts owed under the ESA or for money held by the director in trust. This is important for managing financial aspects related to the enforcement of the Act. Subsection 6 of Section 88 says that any determination made by the director under Subsection 5, such as setting interest rates, is not considered a regulation under the Legislation Act. This means these determinations don't go through the same formal process as regulations. Subsection 7 states that if money is paid to the director in trust and the Act doesn't specify how it should be paid out, it's the director's responsibility to pay it to the rightful person, including interest calculated at the rate they determined. Subsection 8 states, if the interest earned on money held in trust exceeds the amount paid out, the surplus can be used by the director to cover any service charges from the financial institution where the money is held. Subsection 9 says that in exercising any power or making decisions under the Act, the director is not required to hold a hearing. This gives them the flexibility to make decisions without the formalities of a hearing process. In summary, Section 88 provides the Director of Employment Standards with broad authority to interpret, administer, and enforce the Employment Standards Act, including the power to establish policies, delegate responsibilities, set interest rates, and make decisions without a hearing. This section is key to understanding how the ESA is applied and enforced in Ontario. Moving on to Section 88.1 of Ontario's Employment Standards Act, we find provisions relating to the director's authority over the reassignment of investigations conducted by employment standards officers. Subsection 1 of Section 88.1 states that the director has the power to terminate an employment standards officer's assignment to the investigation of a complaint and can reassign that investigation to another officer. This means if, for any reason, the director believes it is necessary to change the officer handling a specific investigation, they have the authority to do so. Subsection 2 details the implications of such a reassignment. Firstly, the officer whose assignment is terminated loses all powers and duties related to investigating that particular complaint. This includes any investigation into similar potential entitlements of other employees of the same employer that might arise from the complaint. Secondly, the new officer assigned to the investigation is allowed to use the evidence collected and any findings of fact made by the first officer. This provision ensures continuity and efficiency in the investigation process, even when the investigating officer is changed. Lastly, subsection 3 extends the application of this section to include inspections of employers by employment standards officers. This means that the same rules about reassigning officers and relying on previously collected evidence or findings apply not only to the investigation of complaints, but also to general inspections conducted by these officers. In essence, Section 88.1 provides the director with flexibility to manage investigations and inspections effectively, ensuring that the process remains fluid and adaptable to changing circumstances or requirements. Moving on to Section 88.2 of Ontario's Employment Standards Act, this section introduces the concept of recognition for employers by the Director of Employment Standards. Under subsection 1, the director has the authority to give recognition to an employer who applies for it, provided that the employer meets certain prescribed criteria. This suggests that there are specific standards or benchmarks that an employer must meet to receive such recognition, which is likely related to their compliance with the ESA or exemplary employment practices. Subsection 2 clarifies that these criteria for recognition can vary for different classes of employers. This means that the criteria set by the director can be tailored to address the unique characteristics or requirements of various types of employers, acknowledging that different industries or sectors may have distinct operational contexts. In subsection 3, the director is given the power to require any employer seeking recognition or already recognized to provide necessary information, records, or accounts pertaining to that recognition. The director can also conduct inquiries and examinations as deemed necessary. This provision ensures that the recognition process is thorough and based on verifiable information. Subsection 4 states that the director may publish or make public information relating to employers given recognition, including their names. This could serve as an incentive for employers, offering public acknowledgement of their compliance or exemplary practices, and also provides transparency in the recognition process. The validity of recognitions is addressed in subsection 5, where it's stated that any recognition granted is valid for a specific period as specified by the director. This implies that recognition is not indefinite and may need renewal or review after a certain time. Finally, subsection 6 gives the director the power to revoke or amend a recognition. This ensures that recognitions remain current and reflective of the employer's ongoing compliance with the prescribed criteria. Overall, Section 88.2 establishes a framework for recognizing employers who meet certain standards, providing a mechanism for both encouraging and acknowledging good employment practices in Ontario. Moving on to Section 88.3 of the ESA, we find the provisions related to the delegation of powers granted to the director under Section 88.2, which concerns the recognition of employers. Subsection 1 of Section 88.3 allows the director to delegate the powers conferred on them under Section 88.2 to an individual employed in the ministry. This delegation can be made either orally or in writing. It means that the director can authorize a staff member in the ministry to carry out certain tasks or make decisions related to the recognition of employers. This could include reviewing applications for recognition, making inquiries, or conducting examinations as necessary. The ability to delegate these tasks helps in the efficient administration of the recognition process. Subsection 2 of Section 88.3 ensures that even if the director delegates these powers, they still retain the ability to exercise them personally. This provision maintains the director's overall authority and oversight over the process of recognizing employers, ensuring that the delegation does not limit their ability to manage and guide the process. Lastly, subsection 3 imposes a duty on any individual who is authorized by the director to exercise these powers. Such individuals are required to follow any policies established by the director under subsection 88.2. This ensures consistency in the administration of the recognition process and adherence to the guidelines and standards set by the director. In summary, Section 88.3 provides the director with the flexibility to delegate certain powers related to employer recognition to other individuals within the ministry, while maintaining overall control and ensuring adherence to established policies. Moving on to Section 89 of the ESA, this section lays out the powers and duties of employment standards officers, who play a key role in enforcing the Act. Subsection 1 of Section 89 establishes that employment standards officers are empowered to exercise the powers given to them under the ESA and are required to perform the duties imposed upon them by the Act. This broadly includes the authority to investigate complaints, inspect workplaces, and ensure compliance with the ESA. It means that these officers are the frontline individuals responsible for the practical enforcement of the Act in workplaces across Ontario. Subsection 2 of Section 89 requires employment standards officers to adhere to any policies established by the director under subsection 2 of Section 88. This ensures that all officers are following a consistent approach in their interpretation, administration, and enforcement of the Act. It helps maintain uniformity in how employment standards are applied and enforced, providing a predictable and standardized process for both employers and employees. Finally, subsection 3 states that employment standards officers are not required to hold a hearing when exercising any of their powers or making decisions under the Act. This provision gives them the flexibility to make determinations and take actions based on investigations and evidence without the need for formal hearings. This can streamline the process of addressing and resolving employment standards issues, making it more efficient. In essence, Section 89 defines the scope of authority and responsibilities of employment standards officers, emphasizing their role in enforcing the ESA and ensuring that they operate within the framework of policies set by the director. Moving on to Section 90 of the ESA, this section addresses the legal limitations on the use of evidence obtained by employment standards officers in civil proceedings. Subsection 1 of this section establishes that employment standards officers are not considered competent or compellable witnesses in civil court cases when it comes to any information they've gathered, statements they've made or received, or records or other items they've produced or received under the Act. However, there's an important exception to this. They can be involved as witnesses for the purpose of carrying out their duties under the Act. This means that while the information officers gather during their enforcement activities is protected from being used in civil lawsuits, it can be used if it's necessary for the officers to fulfill their responsibilities under the ESA. Subsection 2 of Section 90 extends this protection to the physical records or any other items that an employment standards officer has made or received under the Act. An officer cannot be compelled in a civil proceeding to produce these materials except when it's necessary for them to carry out their duties under the Act. This provides a layer of confidentiality to the work of employment standards officers, ensuring that the information and materials they handle in the course of enforcing the ESA are used solely for that purpose and not for other legal disputes. In summary, Section 90 of the ESA provides a legal safeguard for the information and materials gathered by employment standards officers, limiting their use in civil proceedings to only when necessary for the officers to perform their duties under the Act. This ensures the integrity and confidentiality of the enforcement process. Moving on to Section 91 of the Ontario Employment Standards Act, this section delineates the investigation and inspection powers of employment standards officers, crucial for enforcing compliance with the Act. Subsection 1 of Section 91 empowers employment standards officers to enter and inspect any workplace without a warrant as part of investigating possible violations of the Act or ensuring compliance. This authority is key to the proactive and reactive enforcement capabilities of these officers. Subsection 2 stipulates that these powers can only be exercised during the regular business hours of the workplace or, if there are no regular business hours, during daylight hours. This provision balances the need for effective enforcement with respect for the normal operations of a workplace. Subsection 3 limits the power to inspect dwellings used as part of a workplace. Officers cannot inspect parts of a place used as a dwelling without the occupier's consent or a warrant. This respects the privacy of individuals living in or connected to the workplace. Subsection 4 clarifies that employment standards officers are not entitled to use force to enter and inspect a workplace, ensuring that inspections are conducted respectfully and without coercion. Subsection 5 requires officers to produce evidence of their appointment upon request, ensuring transparency and legitimacy in their interactions with employers and employees. Subsection 6 outlines the specific powers officers have during investigations or inspections. They can examine and require the production of relevant records, remove records for review, use business systems to produce readable records, and question any person about matters relevant to the investigation or inspection. Subsection 7 mandates that any demand for record production must be in writing and include a description of the required record, ensuring clarity and specificity in these requests. Subsection 8 imposes an obligation on those in custody of demanded records to produce them and provide necessary assistance to interpret them or produce them in a readable form. Subsection 9 states that if an officer removes a record, they must provide a receipt and return the record within a reasonable time, balancing investigative needs with the rights of the workplace. Subsection 10 asserts that copies of records certified by an employment standards officer have the same legal weight as the original records, facilitating their use in enforcement proceedings. In subsection 10.1 of Section 91, the Employment Standards Act grants employment standards officers the ability to require employers to conduct a self-audit. This self-audit involves a thorough examination of the employer's records and practices to ensure they comply with specific provisions of the Act or its regulations. The requirement for this self-examination is communicated to the employer through a written notice from the officer. Subsection 10.2 mandates that once an employer is directed to perform this self-audit, they must not only conduct the examination thoroughly, but also report the findings back to the employment standards officer. This step ensures that the employer actively engages in assessing their compliance and communicates their findings to the authorities responsible for enforcing the ESA. The notice issued under subsection 10.1, as detailed in subsection 10.3, must include specific information. It should state the period that the audit covers, outline the specific sections of the Act or regulations that need to be audited, and set a deadline for the employer to submit their report. This level of detail ensures that the employer's self-audit is focused and time-bound. In subsection 10.4 of Section 91, the Act allows for the notice to additionally specify the methods the employer should use in the audit, the format for the report, and any other relevant information deemed necessary by the Employment Standards Officer. This flexibility ensures that the self-audit can be tailored to suit different workplace contexts and specific areas of concern. Finally, subsection 10.5 of Section 91 delves into what the employer's report must include. The report should assess whether the employer has complied with the Act or regulations. If non-compliance is found, the report should detail whether any employees are owed wages, along with the steps the employer intends to take for future compliance. Furthermore, if it is identified that employees are owed wages, the employer must list each affected employee, the amount owed, and how these amounts were calculated. This comprehensive approach ensures that any issues of non-compliance are not only identified but also appropriately addressed. Subsections 11 and 12 address potential obstruction of an officer's duties. No person shall hinder, obstruct, refuse to answer questions, or provide false or misleading information during an investigation or inspection. These provisions ensure that officers can conduct their duties without interference. Subsection 13 protects the officer's ability to conduct separate inquiries with individuals, ensuring that they can gather information without undue influence or pressure from others. In summary, Section 91 provides employment standards officers with comprehensive powers to investigate, inspect, and gather information, ensuring effective enforcement of the ESA. It balances these powers with respect for privacy, procedural fairness, and the rights of both employers and employees. Moving on to Section 92 of Ontario's Employment Standards Act, we delve into the provisions regarding the issuance and execution of warrants for employment standards officers. Subsection 1 of this section outlines the conditions under which a justice of the peace can issue a warrant to an employment standards officer. Such a warrant can be issued if there is information under oath indicating that any of the following three things is true. 1. The officer has actually been prevented from exercising a right of entry to the premises under subsection 1 of Section 91, or has been prevented from exercising a power under subsection 6 of Section 91. Or 2, there are reasonable grounds to believe that the officer will be prevented from exercising a right of entry to the premises under subsection 1 of Section 91, or will be prevented from exercising a power under subsection 6 of Section 91. Or 3, there are reasonable grounds to believe that an offense under this Act or the regulations has been or is being committed, and that information or other evidence will be obtained through the exercise of a power mentioned in subsection 6 of Section 91. Subsection 2 of Section 92 stipulates that a warrant must have an expiration date not exceeding 30 days from the date of issuance. This ensures that the warrant is used within a reasonable time frame. Subsection 3 of Section 92 allows for the extension of the warrant's validity. An employment standards officer named in the warrant can apply for an extension without notice, and a justice of the peace may extend the expiration date by no more than an additional 30 days. Subsection 4 permits the employment standards officer named in the warrant to seek assistance from a police officer in executing the warrant. This provision is important for ensuring the safety and effectiveness of the enforcement action, especially in situations where resistance or obstruction is anticipated. Subsection 5 restricts the execution of the warrant to the hours between 8 a.m. and 8 p.m., unless the warrant specifically states otherwise. This limitation respects the normal operating hours of most workplaces and aims to minimize undue disruption. Subsection 6 applies the conditions and limitations set out in subsections 4 to 13 of Section 91 to the execution of a warrant. This means that the same rules and procedures that apply to investigations and inspections without a warrant also apply when a warrant is being executed. Finally, subsection 7 of Section 92 clarifies that when a warrant is executed, the employment standards officer can question individuals about any matters they deem relevant to the investigation or inspection, not just those aiding in the execution of the warrant. This broad scope of questioning is crucial for thorough and effective investigations. In essence, Section 92 provides a legal framework for issuing and executing warrants, equipping employment standards officers with the authority to enter premises and carry out their duties, even in situations where access is initially denied or obstructed. Moving on to Section 93 of the ESA, this section focuses on the authority of employment standards officers to require employers to post notices in their workplaces. This is a key part of ensuring that employees are informed about matters related to the administration or enforcement of the Act. Under this section, an employment standards officer can direct an employer to post and maintain notices in a visible and accessible location on the employer's premises. These notices can serve various purposes, including the following two things. First, the officer officer can require the posting of any notice relating to the administration or enforcement of the ESA or its regulations. This could include information about employee rights, employer obligations, updates to the legislation, or other relevant details. The aim is to ensure that employees are kept informed about matters that directly affect their employment and rights under the Act. Second, the officer can require employers to post a copy or part of a report made by the officer concerning the results of an investigation or inspection. This is particularly important for transparency and accountability, as it allows employees to be aware of the findings of any investigations or inspections that have taken place in their workplace. The requirement that these notices be placed in a conspicuous location where they are likely to be seen by employees is crucial. It ensures that the posted information is accessible and visible to all employees, thereby enhancing their awareness and understanding of their rights and the outcomes of any relevant ESA-related activities or findings in their workplace. In summary, Section 93 empowers employment standards officers to use workplace postings as a tool for disseminating important information related to the ESA, fostering an informed workforce, and promoting compliance within the workplace. Moving on to Section 94 of the ESA, this section outlines the interaction between the ESA and the Federal Canada Labour Code, particularly in the context of regulations made under the Canada Labour Code that incorporate parts of the ESA or its regulations. Section 94 specifies that if a regulation is made under the Canada Labour Code that incorporates all or part of the ESA or its regulations, then the Canada Industrial Relations Board and any person who has powers under the ESA can exercise those powers as conferred under the Canada Labour Code regulation. Essentially, this provision creates a legal bridge between the two legislative frameworks, allowing for the application of certain aspects of Ontario's ESA within the context of the Federal Canada Labour Code. This could occur, for instance, in situations where federal regulations aim to align with provincial standards for consistency or when trying to apply certain employment standards more broadly across jurisdictions. When such an incorporation happens, those who are empowered to enforce the ESA, like employment standards officers, are also granted the authority to exercise their powers in the context of the corresponding federal regulation. This provision is particularly significant for employers and employees who operate under the jurisdiction of the Canada Labour Code, but are also subject to aspects of the Ontario ESA. It ensures that certain standards and protections provided under the ESA are upheld even within the federal framework, facilitating a more harmonized approach to employment standards across different levels of government. In summary, Section 94 of the ESA allows for the seamless application and enforcement of certain parts of the Act or its regulations when they are incorporated into regulations under the Canada Labour Code, ensuring consistency and compliance across provincial and federal jurisdictions. Moving on to Section 95. This section elaborates on the methods and efficacy of serving documents under the Act, which is critical for ensuring that legal notifications are properly communicated. Subsection 1 of Section 95 details various ways documents can be served under the Act. These include personal service, directly to an individual or a representative of a corporation, mailing to the last known business or residential address, sending by fax or email if the recipient can receive them, using a courier service, leaving the document with an individual who appears to be at least 16 years old at the last known address, or any other manner ordered by the board. Subsection 2 of Section 95 clarifies that service is effective when the document is left with the individual in cases of personal service. Subsection 3 states that, subject to Subsection 6, service by mail is considered effective 5 days after the document is mailed. This provides a buffer to account for mailing time. Subsection 4 addresses service by fax or email, noting that if sent on weekends, public holidays, or after 5 p.m. on a weekday, service is effective on the next business day. Subsection 5 explains that, subject to Subsection 6, service by courier is effective 2 days after the courier takes the document, allowing time for delivery. Subsection 6 provides an exception to the effective service time stated in subsections 3, 4, and 5. If a person can prove that they did not receive the service effectively at the specified time due to absence, accident, illness, or a cause beyond their control, these timing rules do not apply. Subsection 7 allows the director to direct the board to consider a different manner of service if none of the methods in Subsection 1 are appropriate in certain circumstances. Subsection 8 states that the board can order service to be effected in a manner it considers appropriate if directed to consider the manner of service. Subsection 9 mandates that the board, in its order for service, must specify when the service is effective, ensuring clarity in the timing of the legal notification. Subsections 10 and 11 deal with proof of service. A certificate of service made by the employment standards officer or the person who served the document is evidence of the issuance and receipt of the order or notice, provided it certifies that the document is a true copy, was served on the person person and specifies the method of service used. In essence, Section 95 provides a comprehensive framework for the service of documents under the ESA, detailing methods of service, the timing of their effectiveness, and the proof required to validate that service has occurred. So that brings us to the end of Part 21 of the ESA, and we've got 4 parts left to go, each of which has a variety of sections and subsections contained within them. By this point in the video, you have an in-depth understanding of who enforces the ESA and what they can do. Now let's move on to Part 22, which deals with how complaints and enforcement are handled. Moving on to Section 96, this section is vital as it outlines the process for filing complaints under the ESA. Subsection 1 of Section 96 allows any person who believes there has been a contravention of the Act to file a complaint with the Ministry. The complaint must be submitted in either a written or electronic form that is approved by the Director. This provision ensures that complaints are standardized and contain all necessary information for the Ministry to proceed with an investigation. Subsection 2 addresses the importance of using the correct form for filing a complaint. It states that any complaint not filed using a form approved by the Director is deemed not to have been filed. This requirement underscores the need for compliance with procedural norms when raising concerns under the ESA. Finally, subsection 3 introduces a limitation period for filing complaints. It stipulates that complaints about a contravention that occurred more than 2 years before the date of filing are deemed not to have been filed. This limitation period ensures that complaints are timely and relevant to current employment conditions, allowing for more efficient resolution and enforcement. In summary, Section 96 of the ESA provides the framework for how individuals can formally raise concerns about violations of the Act, emphasizing the importance of using approved forms and adhering to the specified time limits for submitting complaints. Moving on to Section 97 of the ESA, we delve into the restrictions placed on employees regarding civil proceedings once they have filed a complaint under the Act. Subsection 1 of this section states that an employee who files a complaint under the ESA regarding unpaid wages or issues related to benefit plans as covered in Part 13 of the Act is not permitted to also initiate a civil proceeding based on the same matter. This means that once an employee chooses the avenue of filing a complaint with the Ministry about these issues, they cannot concurrently pursue the matter through a civil lawsuit. The intent here is to prevent dual processing of the same claim through different legal channels, which could lead to conflicting outcomes and legal inefficiencies. Subsection 2 extends this restriction to cases involving wrongful dismissal. An employee who files a complaint alleging entitlement to termination pay or severance pay under the ESA cannot simultaneously commence a civil proceeding for wrongful dismissal if both the complaint and the civil case pertain to the same termination or severance of employment. This provision ensures that an employee chooses either the administrative remedy provided under the ESA or the judicial remedy of a civil lawsuit, but not both for the same issue. Subsection 3 has been repealed and is no longer applicable. Subsection 4 provides an exception to these restrictions. It allows an employee who has filed a complaint under the ESA to commence a civil lawsuit related to the same matter, provided they withdraw their complaint within 2 weeks of filing it. This gives employees the flexibility to reassess their chosen course of action shortly after filing a complaint, allowing them to switch to a civil proceeding if they believe it better suits their situation. In summary, Section 97 of the ESA delineates the limitations on pursuing civil proceedings once an employee has filed a complaint under the Act, aiming to streamline the dispute resolution process and prevent overlapping claims in different legal forums. Moving on to Section 98, this section addresses the limitations on employees regarding the filing of complaints under the Act if they have already initiated a civil lawsuit for related issues. Subsection 1 of this section sets out that an employee who has commenced a civil lawsuit concerning unpaid wages or non-compliance with Part 13 of the Act, which deals with benefit plans, is prohibited from filing a complaint under the ESA on the same matter. Furthermore, they cannot have such a complaint investigated. This is essentially the converse of the provision in Section 97. While Section 97 restricts an employee from initiating a civil proceeding after filing a complaint, Section 98 restricts them from filing a complaint after initiating a civil proceeding. The objective is to ensure that an employee chooses a single legal avenue, either the ESA's administrative process or the civil court system, to address their grievance. Subsection 2 of Section 98 mirrors this restriction in the context of wrongful dismissal claims. It stipulates that if an employee has already started a civil lawsuit for wrongful dismissal, they are not allowed to file a complaint under the ESA claiming entitlement to termination pay or severance pay, nor can they have such a complaint investigated if the lawsuit and the complaint concern the same termination or severance of employment. This ensures that the matter is addressed through one legal channel only, either through the courts or through the administrative process under the ESA, but not both simultaneously. In summary, Section 98 of the ESA provides a clear directive that employees must choose between pursuing a civil lawsuit and filing a complaint under the Act when it comes to issues of unpaid wages, benefit plan compliance, or wrongful dismissal. This approach is designed to prevent duplicative legal processes and to streamline the resolution of employment-related disputes. Moving on to Section 99. This section deals with the enforcement of the Act in the context of unionized workplaces and collective agreements. Subsection 1 of this section specifies that if an employer is or has been bound by a collective agreement, the ESA is enforceable against the employer as if it were part of that collective agreement. This is applicable in cases of alleged contraventions of the Act that occur during the time the collective agreement is or was in force, when its operation is or was continued under the Labor Relations Act, or during a period when the parties to the agreement are or were prohibited from unilaterally changing employment terms and conditions. Essentially, this means that the provisions of the ESA are integrated into the collective agreement and can be enforced as such. Subsection 2 places a limitation on employees who are represented by a trade union that is or was a party to a collective agreement. Such employees cannot file a complaint under the ESA regarding a matter that is enforceable under the collective agreement or have such a complaint investigated. This underscores the principle that in unionized environments, the collective agreement, along with the grievance and arbitration mechanisms within it, is the primary avenue for addressing employment issues. Subsection 3 binds employees represented by a trade union to any decisions made by the union concerning the enforcement of the ESA under the collective agreement. This includes decisions not to seek enforcement. It highlights the collective nature of labor relations in unionized workplaces, where the union's decisions are binding on all members. Subsection 4 clarifies that the restrictions in subsections 2 and 3 apply regardless of the employee's membership status in the trade union. Subsection 5 provides an exception, allowing employees to file a complaint with the board alleging unfair representation by the trade union in enforcing the Act, as per Section 74 of the Labor Relations Act. This gives employees a recourse if they believe the union is not adequately representing their interests in enforcing the ESA. Finally, subsection 6 of Section 99 allows for exceptions to the restriction in subsection 2. The director may permit an employee to file a complaint and direct an employment standards officer to investigate it if considered appropriate in the circumstances. This allows for some flexibility in cases where filing a complaint under the ESA might be necessary or more appropriate. In summary, Section 99 of the ESA outlines how the Act applies in unionized workplaces with collective agreements, emphasizing the primary role of collective bargaining and union representation in such environments while providing avenues for recourse in specific situations. Moving on to Section 100, this section outlines the powers of arbitrators in cases where an employer is found to have contravened the Act. Subsection 1 of Section 100 states that if an arbitrator, during a grievance or arbitration proceeding, finds that an employer has contravened the ESA, the arbitrator is empowered to make any order against the employer that an employment standards officer could have made. This includes orders to rectify the contravention and possibly compensate the affected employees. However, the arbitrator is not authorized to issue a notice of contravention, which is a formal document typically issued by employment standards officers that outlines the nature of the violation. Subsection 2 deals specifically with contraventions of Part 13 of the Act, which covers benefit plans. In such cases, an arbitrator can make any order that the Labor Relations Board could make under Section 121 of the ESA. This expands the arbitrator's authority in matters related to benefit plans, allowing them to issue comprehensive orders to ensure compliance with this part of the Act. Subsection 3 limits the arbitrator's powers regarding orders against directors in the context of collective agreements. It stipulates that an arbitrator cannot require a director to pay an amount, take an action, or refrain from taking an action under a collective agreement that they could not be ordered to do outside of the collective agreement context. This ensures that the obligations imposed on directors are consistent, regardless of whether a collective agreement is in place. Subsection 4 sets out conditions for orders made by arbitrators. Firstly, if the order involves the payment of wages or compensation, the arbitrator can direct the payment either to the trade union representing the employees or directly to the employees themselves. Secondly, it's specified that the order is not subject to review under Section 116 of the ESA, which means the arbitrator's decision in these matters is final. Subsection 5 requires arbitrators to provide a copy of their decision regarding any alleged contravention of the ESA to the director. This ensures that the enforcement arm of the ministry is informed about the findings and orders issued in arbitration proceedings related to the Act. In summary, Section 100 grants arbitrators the authority to issue orders against employers found to have contravened the ESA, with specific provisions regarding benefit plans and the handling of orders, ensuring that the arbitration process aligns with the objectives and enforcement mechanisms of the Act. Moving on to Section 101, this section deals with the role of arbitrators and the Labor Relations Board in determining whether different entities are to be treated as one employer under the Act, particularly in the context of arbitration proceedings involving collective agreements. Subsection 1 of Section 101 sets the context for this section, applying when, during an arbitration proceeding, other than those before the board, an issue arises about whether an employer under a collective agreement and another entity should be treated as a single employer under Section 4 of the ESA. Subsection 2 of this section places a restriction on the arbitrator's authority by stating that the arbitrator shall not decide whether the employer and another person are to be treated as one employer under Section 4. This limitation acknowledges that such determinations can be complex and may require a broader legal perspective. Subsection 3 provides a procedure for cases where it becomes necessary to determine the application of Section 4 during arbitration. The arbitrator is required to refer this specific question to the Labor Relations Board, the board, by giving written notice. Subsection 4 details the content of this notice. It must state that the issue of whether the employer and another person are to be treated as one employer under Section 4 has arisen in the arbitration proceeding and also outline the arbitrator's decisions on other disputed matters. Subsection 5 assigns the responsibility to the board to decide whether the employer and the other person are one employer under Section 4. However, the board is not authorized to alter any of the arbitrator's decisions regarding other matters in the dispute. Subsection 6 states that the board may issue orders against the employer, and if it finds that the employer and the other person are indeed one employer under Section 4, it may also issue orders against this other person. This ensures that all parties who are effectively operating as a single employer are held accountable. Subsection 7 imposes a limitation, stating that the board shall not require the other person to undertake or refrain from actions under a collective agreement that they would not be bound to in the absence of such an agreement. This maintains fairness and legal consistency. Finally, subsection 8 notes that Section 100 of the ESA applies to orders under this section, albeit with necessary modifications. This ties the board's authority in these matters to the broader framework of the ESA's enforcement mechanisms. In summary, Section 101 of the ESA provides a clear process for addressing complex issues related to the definition of employer in arbitration proceedings, ensuring that such matters are referred to and decided by the Labor Relations Board. Moving on to Section 101.1 of the ESA, this section introduces provisions related to the settlement of complaints by an employment standards officer. Subsection 1 empowers an employment standards officer who is assigned to investigate a complaint to attempt to mediate a settlement between the employer and the employee. This offers a mechanism for resolving disputes without proceeding through the entire investigation or legal process, potentially saving time and resources for both parties. Subsection 2 outlines the effects of a successful settlement. If both the employer and employee agree to the settlement and fulfill their respective obligations under it, several things happen. First, the settlement becomes binding on both parties. Second, the complaint is deemed to have been withdrawn, meaning it is treated as if the employee never filed it. Third, the investigation by the employment standards officer is terminated, ending the formal inquiry into the complaint. And finally, fourth, any legal proceeding other than a criminal prosecution regarding the contravention alleged in the complaint is also terminated, closing any ongoing administrative or legal actions related to the issue. Subsection 3 states that subsections 4, 5, 7, and 9 of Section 112 of the ESA apply to settlements under this section, with necessary modifications. We'll get to those subsections later in this video, but those provisions, generally related to the enforcement of orders and agreements, ensure that the settlements are treated with the same legal weight and follow similar enforcement mechanisms. Subsection 4 provides a safeguard against unfair settlements. If either the employee or employer applies to the board and demonstrates that they entered into the settlement due to fraud or coercion, the following consequences happen. First, the settlement is declared void, meaning it has no legal effect. Second, the complaint is considered never to have been withdrawn, effectively reinstating it. Third, the investigation of the complaint is resumed, reopening the inquiry into the alleged contravention. And finally, fourth, any legal proceedings related to the complaint that were terminated are also resumed, allowing legal or administrative actions to continue. In summary, Section 101.1 of the ESA facilitates the resolution of disputes through settlements mediated by an employment standards officer, while also providing measures to protect parties from unfair settlement agreements. Moving on to Section 102. This section discusses the conditions under which an employment standards officer can require certain individuals to attend a meeting as part of an investigation or inspection. Subsection 1 allows an employment standards officer to request a meeting with specific persons after providing at at least 15 days written notice. Such a meeting can be called under several circumstances: during an investigation of a complaint against an employer, when, during an inspection, the officer believes there might be a contravention of the act, upon acquiring information suggesting a potential contravention, or to determine compliance in cases where an employee resides in the employer's residence. Subsection 2 specifies who can be required to attend these meetings. This includes the employee involved, the employer, or if the employer is a corporation, a director, or employee of the corporation. Subsection 3 requires that the notice given under subsection 1 should specify the time and place of the meeting and must be served in accordance with Section 95 of the ESA, ensuring proper and formal communication. Subsection 4 states that the Employment Standards Officer may require the person attending the meeting to bring or make available specified records or other documents. Subsection 5 allows the officer to give directions on how to make these documents available for the meeting, ensuring that all necessary information is accessible during the meeting. Subsection 6 mandates that a person who receives a notice under this section must comply with it, emphasizing the importance of cooperation in the investigation process. Subsection 7 introduces the possibility of using technology such as teleconferencing or video conferencing for these meetings, allowing for flexibility in how the meetings are conducted. Subsection 8 notes that if a meeting is to be held using technology, the officer should include additional relevant information in the notice. Subsection 9 clarifies that participation in a meeting via technological means is considered as attendance for the purposes of this section. Subsection 10 details the procedure if a person fails to attend the meeting or bring the required documents. In such cases, the officer may make a determination about an employer's contravention of the act based on the evidence and submissions provided by the employer and employee, as well as any other relevant factors. Subsection 11 specifies that for the purposes of subsection 10, if the employer is a corporation, employer includes a director or employee who was served with the notice for the meeting. In this context, the word director isn't referring to the Director of Employment Standards at the Ministry of Labor. Rather, the word director is referring to a member of the board of directors of the employer, if the employer is a corporation. In summary, Section 102 of the ESA provides a structured approach for employment standards officers to conduct meetings with relevant parties during investigations or inspections, ensuring thoroughness and compliance in the enforcement process. Moving on to Section 102.1, this section addresses the procedure for an employment standards officer to require responses from employers or employees during investigations or inspections. Subsection 1 grants an employment standards officer the authority to request evidence or submissions from an employer or employee within a specified time frame in various circumstances. These situations include when the officer is investigating a complaint against an employer, has reasonable grounds to believe during an inspection that an employer has contravened the act or its regulations with respect to an employee, acquires information suggesting a possible contravention by an employer, or wishes to ascertain compliance by an employer of an employee residing in the employer's residence. The ability to demand timely evidence or submissions is crucial for the effective and efficient progression of the officer's investigation or inspection. Subsection 2 mandates that the notice given to the employer or employee, as referenced in subsection 1, should be served in accordance with Section 95 of the ESA. This ensures the formal and legal delivery of such notices, maintaining procedural integrity. Subsection 3 outlines the consequences if the person served with the notice fails to provide the requested evidence or submissions within the specified time. In such cases, the Employment Standards Officer can make a determination about whether the employer has contravened or is contravening the act based on various factors. These include any evidence or submissions provided by or on behalf of the employer or employee before the notice was served, any responses provided within the time frame specified in the notice, and any other relevant factors the officer considers important. This allows the officer to make an informed decision even in the absence of a response, ensuring that the investigation or inspection can proceed to a conclusion. In summary, Section 102.1 of the ESA sets out a procedure for employment standards officers to request and receive timely evidence or submissions from employers and employees as part of the investigative or inspection process, with clear guidelines on how to proceed if there is a failure to respond. Moving on to Section 103 of Ontario's Employment Standards Act. This section provides the authority for employment standards officers to issue orders for the payment of wages owed by employers to employees. Subsection 1 outlines the options available to an employment standards officer if they find that an employer owes wages to an employee employee. The officer may either arrange for the employer to pay the wages directly to the employee, order the employer to pay the wages to the employee, or order the employer to pay the amount of wages owed to the director in trust. These options provide flexibility in ensuring that owed wages are paid in a manner that is feasible and appropriate for the specific situation. Subsection 2 addresses administrative costs associated with the order. If the officer issues an order under Clause B of subsection 1 for the employer to pay wages to the director in trust, the employer is also required to pay an amount for administrative costs. This amount is the greater of $100 or 10% of the wages owing, ensuring that the administrative expenses incurred in handling the trust payments are covered. Subsection 3 allows for a single order to be issued regarding wages owed to multiple employees, streamlining the process for cases involving multiple affected workers. Subsection 4 was repealed in 2014 and is no longer in effect, so we're going to skip that one. Subsection 5 requires that the order includes information about the nature of the amount found to be owing, or that such information is provided alongside the order. This ensures clarity and transparency about the reason and the amount of wages owed. Subsection 6 mandates that the order be served on the employer in accordance with Section 95, ensuring formal and legal delivery of the order. Subsection 7 states that when an employment standards officer issues an order with respect to an employee, they must advise the employee of its issuance by serving a letter in accordance with Section 95. This keeps the affected employee informed about the enforcement action being taken on their behalf. Subsection 8 obligates every employer against whom an order is issued under this section to comply with it according to its terms, emphasizing the mandatory nature of these orders. Subsections 9 and 10 deal with the finality of the order. If the employer does not apply for a review of the order under Section 116 within the allowed time, the order becomes final and binding. Subsection 10 clarifies that this finality applies even if there is a review hearing under the Act to determine another person's liability for the wages in question. In summary, Section 103 of the ESA provides a comprehensive framework for employment standards officers to order the payment of owed wages by employers, ensuring that employees receive the wages they are entitled to in a timely and efficient manner. Moving on to Section 104, this section empowers employment standards officers to issue orders for compensation and reinstatement or hiring in cases of contraventions related to specific parts of the Act. Subsection 1 of this section provides that if an employment standards officer finds a contravention of certain parts of the Act with respect to an employee, they may order compensation for any loss incurred due to the contravention, reinstatement of the employee, or both. The applicable parts of the Act include Part 24, which is about leaves of absence, Part 26, which is about lie detectors, Part 27, which is about retail business establishments, and Part 28, which is about reprisals. This gives officers the authority to redress wrongs not just in terms of financial compensation, but also by restoring the employee's job position when appropriate. Subsection 2 deals with contraventions of Part 26, again about lie detectors. In these instances, an employment standards officer may order that a job applicant or an applicant to be a police officer be hired by the employer or be compensated, or both. This subsection specifically addresses the misuse of lie detectors in employment contexts and provides remedies to applicants who have been wrongfully denied employment due to such contraventions. Subsection 3 outlines the terms of orders that require a person to compensate an employee. The order may require the person to either pay the compensation and an additional amount for administrative costs to the director in trust or pay the compensation directly to the employee. The amount for administrative costs is the greater of $100 or 10% of the compensation amount, ensuring the recovery of costs incurred in administering these orders. Subsection 4 states that the provisions in subsections 3 and 5 to 9 in Section 103 apply to orders issued under Section 104 with necessary modifications. This means that the same procedures and rules for service, compliance, and the effect of orders as outlined in Section 103 are also applicable to orders under Section 104. By the way, if you haven't noticed by now, the term service is just another word for document delivery. In summary, Section 104 of the ESA allows employment standards officers to issue orders for compensation, reinstatement, or hiring in response to certain specific violations of the Act, providing a robust mechanism for redressing wrongs and enforcing compliance with the Act's provisions. Moving on to Section 105 of the ESA, this section addresses the protocol for situations where an employee owed wages cannot be located by the employer. Subsection 1 of this section deals with instances where an employment standards officer has arranged with an employer or ordered an employer to pay wages to an employee as per clause A or A.1 of subsection 1 of section 103, but the employer is unable to find the employee despite reasonable efforts. In such cases, the employer is required to pay these wages to the director in trust. This provision ensures that the wages are safeguarded and can potentially be claimed by the employee in the future, even if they are presently unreachable. Subsection 2 extends a similar procedure to settlements. If an employment standards officer has received money for an employee under a settlement and the employee cannot be located, this money must also be paid to the director in trust. Again, this ensures that the money is kept safe and available for the employee should they later be located. Subsection 3 clarifies the legal status of the money held in trust. The money paid to or held by the director in trust under this section becomes property of the Crown, but can be paid out to the employee's estate, or another person deemed entitled to it by the director. This subsection does not allow for the accrual of interest on the held funds, but it provides a mechanism for the funds to be distributed to the rightful owner or their legal successors. In summary, Section 105 of the ESA outlines the steps to be taken when an employee owed wages or settlement money cannot be located, ensuring that these funds are securely held in trust until the employee or a rightful claimant can be identified and the funds released to them. Moving on to Section 106, this section details the conditions under which directors of a company can be held liable for wages owed by their corporation. Subsection 1 of this section states that if an employment standards officer issues an order against an employer to pay wages, they may also issue an order against some or all of the directors of the employer for the wages liable under Part 20 of the Act. This order against the directors is to be served along with a copy of the order against the employer in accordance with Section 95. This provision ensures that directors are held accountable for unpaid wages, reflecting their responsibility in corporate governance. Subsection 2 outlines the effect of such an order on the directors. If the directors do not comply with the order or fail to apply for its review, the order becomes final and binding against them. This finality applies even if there is a review hearing held to determine someone else's liability under the Act. This clause emphasizes the importance of directors' compliance with orders regarding wage payments. Subsection 3 specifically addresses situations where the employer is insolvent. If an employee files a claim for unpaid wages with a receiver or trustee in bankruptcy and the claim is not paid, the employment standards officer may issue an order against the directors for the unpaid wages. The order must be served in accordance with Section 95. This ensures that employees' wage claims are pursued even in the context of an employer's insolvency. Subsection 4 applies the procedures outlined in Subsection 2 to orders made under Subsection 3, ensuring consistency in the application of these provisions. Subsection 5 clarifies that nothing in this section increases the maximum liability of a director beyond the amounts specified in Section 81 of the Act. This maintains a limit on the financial responsibility that can be imposed on directors. Subsection 6 gives the Director of Employment Standards discretion to order a director of a corporation that is subject to an order under this section to pay the wages in trust to the Director of Employment Standards. This provides a mechanism for the collection and distribution of wages owed under the supervision of the director. In summary, Section 106 of the ESA empowers employment standards officers to hold directors of companies liable for unpaid wages with specific provisions to address situations of insolvency and to ensure the director's compliance with orders for wage payment. Moving on to Section 107, this section pertains to the issuance of further orders against directors for unpaid wages under circumstances where previous orders have not been fulfilled. Subsection 1 of this section allows an employment standards officer to issue an order for payment of wages for which directors are liable under Part 20 of the ESA against directors of an employer who were not initially subject to an order under Section 106. This order can be served, meaning delivered, to these directors in accordance with Section 95, and it can be issued in several situations. 1. After an order against the employer under Section 103 for wage payment has not been complied with, and the employer has not sought a review of this order. 2. Following an order against directors under subsections 1 or 3 of Section 106 if the required amount has not been paid and neither the employer nor the directors have applied for a review of the order. And 3. After the Labor Relations Board has issued, amended, or affirmed an order under Section 119 that requires the employer or the directors to pay wages and the specified amount has not been paid. paid. This provision ensures that responsibility for unpaid wages can be extended to other directors of the company if the initial orders are not complied with, thereby widening the scope for recovering owed wages. Subsection 2 of Section 107 grants the Director of Employment Standards the discretion to order a director of a corporation that is already subject to an order under this section to pay the wages in trust to the Director of Employment Standards. This offers an additional method for collecting and managing the payment of owed wages, ensuring that they are appropriately disbursed to the entitled employees. In summary, Section 107 of the Act provides a mechanism for employment standards officers to issue further orders for wage payment against directors of an employer, broadening the accountability for unpaid wages, especially in cases where initial orders are not fulfilled. Moving on to Section 108, this section provides employment standards officers with the authority to issue compliance orders to persons who have contravened provisions of the Act or its regulations. Subsection 1 of Section 108 outlines the powers of an employment standards officer in issuing compliance orders. If an officer finds that a person has contravened a provision of the Act or regulations, they may order the person to do any or all of the following things. 1. Cease contravening the provision. 2. Take specific actions or refrain from certain actions to comply with the provision. And 3. Specify a date by which these actions must be taken or refrained from. This approach aims to correct the contravention and bring the person back into compliance with the law. Subsection 2 of Section 108 clarifies that a compliance order under this section cannot require the payment of wages, fees, or compensation. This differentiates compliance orders from other types of orders like those for wage payment. Subsection 3 ensures that the limitation in Subsection 2 does not prevent an employment standards officer from issuing orders under various other sections of the Act in conjunction with a compliance order under this section. This means an officer can issue a compliance order and also order wage payments or other remedies under sections like 74.14, 74.16, 74.17, 74.19, 103, 104, 106, or 107 for the same contravention. Subsection 4 of Section 108 extends the applicability of subsection 6 to 9 of Section 103 to orders issued under Section 108 with necessary modifications. I realize that was an absolute wasp nest of legal jargon and legalese, so please do not even try to memorize those section numbers. The nice thing about YouTube videos is that you can pause them and you can click on timestamps in this video or any of my other videos, and you can refresh your memory about what certain sections say so that you can more easily tie them all together. But getting back to those extended definitions, I mentioned a couple seconds ago regarding how subsection 4 of Section 108 extends the applicability of subsection 6 to 9 of Section 103 to orders issued under Section 108 with necessary modifications. This includes expanding the definitions of employer to include clients of temporary help agencies, recruiters, or prospective employers, and employee to include assignment employees, prospective assignment employees, or individuals using the services of a recruiter. This broadens the scope of compliance orders to include various employment relationships. Subsection 5 allows the director to seek an injunction from a judge of the Superior Court of Justice to restrain the contravention of an order made under subsection 1. This legal mechanism provides a powerful tool to enforce compliance orders. Subsection 6 states that the ability to seek an injunction under subsection 5 is in addition to any other remedy or penalty for contravening an order. An injunction is a court order telling you to do or not do something. This means that seeking an injunction does not preclude other penalties or remedies for non-compliance. Also, the word remedy is commonly used in medicine, but it is also commonly used in law to refer to a legal solution to a problem, usually imposed by a judge or another individual in a position of legal authority. In summary, Section 108 of the ESA empowers employment standards officers to issue orders to ensure compliance with the Act, providing a range of tools and mechanisms to address and rectify contraventions. Moving on to Section 109 of the ESA, this section outlines the procedures for handling money paid to the director under various orders and the protection afforded to the director in executing these duties. Subsection 1 of Section 109 addresses the distribution of money that has been paid to the director under specific types of orders, including those under Sections 74.14, 74.16, 74.17, 74.19, 103, 104, 106, or 107. The money is to be paid to the person for whom the order was issued unless a review of the order is requested under Section 116 within the required period. This provision ensures that money paid under an order is held temporarily by the director and then dispersed to the intended recipient unless the order is being contested. Subsection 2 of Section 109 deals with situations where the money paid to the director is insufficient to fully satisfy the amounts owed to all entitled persons under an order. In such cases, the director is required to distribute the money, including any received for administrative costs, loss, proportionally to the persons according to their entitlement. This provides a fair and equitable method of distribution when the available funds are inadequate to meet all the claims. Subsection 3 provides legal protection to the director, stating that no legal proceedings can be initiated against the director for actions taken in compliance with this section. This shields the director from liability when performing their duties in accordance with the law, particularly in the distribution of funds as per the ESA. In summary, Section 109 sets forth the procedures for the distribution of funds paid under certain orders to the director and ensures that these funds are allocated fairly to the entitled persons. It also provides a legal protection to the director for actions taken in the course of administering these funds. Moving on to Section 110, this section addresses the process and implications when an employment standards officer decides not to issue an order following a complaint alleging a contravention of the Act. Subsection 1 of Section 110 stipulates that if, after a complaint has been filed alleging a contravention of the Act, specifically one for which an order could be issued under Section 74.14, 74.16, 74.17, 74.19, 103, 104, 106, or 108, the assigned employment standards officer decides not to issue such an order, they must serve a letter to the complainant explaining the refusal. This notification must be served in accordance with Section 95 of the Act. This provision ensures transparency in the complaint investigation process, requiring officers to formally communicate their decision not to take further action on a complaint. Subsection 2 of Section 110 introduces the concept of a deemed refusal. It states that if no order is issued within 2 years after a complaint has been filed, the employment standards officer is considered to have refused to issue an order. In this case, it is deemed that a letter advising the complainant of this refusal has been served on the last day of the second year following the filing of the complaint. This subsection addresses situations where there has been a significant delay in processing a complaint, effectively putting a time limit on the decision-making process and providing closure to the complainant in cases where no action has been taken within a reasonable time frame. In summary, Section 110 of the ESA outlines the requirements for employment standards officers to notify complainants when they decide not to issue an order in response to a complaint, and it establishes a timeline for this decision-making process, promoting accountability and timeliness in handling complaints. Moving on to Section 111, this section establishes time limits for recovering wages through complaints and inspections under the Act. Subsection 1 of Section 111 pertains to complaints filed by employees. It states that an employment standards officer investigating such a complaint cannot issue an order for wages that became due more than 2 years before the complaint was filed. This applies to wages due under the specific provision of the Act or regulations that was the subject of the complaint, as well as any other provision of the Act or regulations. This subsection effectively sets a 2-year limitation period for the recovery of wages through a complaint process. Subsection 2 extends this time limit to situations uncovered during the investigation of a complaint, even if it involves employees who did not file the complaint themselves. If an officer, while investigating a complaint, discovers that an employer has contravened the Act or regulations with respect to another employee, the officer cannot issue an order for wages due to that employee if the wages became due more than 2 years before the initial complaint was filed. This ensures consistency in the application of the 2-year limitation period, regardless of whether the affected employee filed the complaint. Subsection 3 addresses findings during inspections. If an employment standards officer during an inspection finds that an employer has contravened the Act or regulations with respect to an employee, the officer cannot issue an order for wages that became due to the employee more than 2 years before the commencement of the inspection. This mirrors the limitation period applied in complaint investigations, applying a 2-year cap to the recovery of wages discovered in contraventions found during inspections. In summary, Section 111 of the ESA sets a 2-year limitation period for the issuance of orders for unpaid wages, whether discovered through a complaint filed by an employee during the investigation of such a complaint or during an inspection. This establishes a clear time frame for the recovery of wages under the Act. Moving on to Section 112, this section deals with the legal implications of settlements reached between an employee and employer concerning a contravention or alleged contravention of the Act. Subsection 1 of this section lays out the consequences when an employee and employer agree to a settlement and inform an employment standards officer in writing of its terms. If they adhere to the terms of the settlement becomes binding. Any related complaints are considered withdrawn. Any orders made regarding the contravention are voided, and all but criminal proceedings concerning the contravention are terminated. This provision establishes the finality and binding nature of such settlements. Subsection 2 specifies that Clause C of Subsection 1 of Section 100 112 does not apply to orders issued under Section 108, which deals with compliance orders. This means that even if there is a settlement, compliance orders remain in effect. Subsection 3 clarifies that this section does not apply to notices of contravention, indicating that settlements do not affect such notices. Subsections 4 and 5 address the handling of money received by an employment standards officer under a settlement. The officer can either pay it directly to the employee or pay it to the director in trust, who then must pay it to the employee. Subsection 6 stipulates that even if there is a settlement concerning an order to pay, the director is still entitled to a proportion of administrative costs and collector's fees and disbursements related to the order. Subsections 7 and 7.1 impose restrictions on settlements, stating that no settlement can permit or require future contraventions of the Act. Specifically, subsection 7.1 emphasizes that settlements cannot allow temporary help agencies or recruiters to operate without a license in contravention of the Act. Subsection 8 allows for the voiding of a settlement if, upon application to the board, the employee can show that the settlement was entered into because of fraud or coercion. In such cases, the settlement is void, the complaint is reinstated, any orders are reinstated, and terminated proceedings are resumed. Subsection 9 modifies the application of this section for Part 18.1, which relates to temporary help agencies and recruiters. We aren't going to be talking about Part 18.1 in this video, but it broadens the definition of employer and employee to include clients of temporary help agencies and recruiters, as well as assignment employees and prospective employees engaging with recruiters. I'll be making another video about that, so you can learn all about temporary help agencies in that video. In essence, Section 112 provides a framework for the legal effect of settlements between employees and employers regarding alleged contraventions of the Act, along with safeguards to prevent abuse of the settlement process. Moving on to Section 113, this section outlines the process for issuing a notice of contravention and the associated penalties under the Act. Subsection 1 of this section allows an employment standards officer who believes that a person has contravened a provision of the Act to issue a notice to that person. This notice outlines the officer's belief and specifies the amount of the penalty for the contravention. Subsection 1.1 states that the amount of the penalty is determined according to the regulations, while subsection 1.2 of this section adds that if a range of penalties has been prescribed for a contravention, the officer must determine the penalty amount based on prescribed criteria. So what do the regulations have to say about the amounts of the penalties? That information can be found in Ontario Regulation 289/01, otherwise known as Penalties and Reciprocal Enforcement. I've decided not to list out the penalty for every type of contravention in this video, and instead I've put a link to this regulation in the description. Generally speaking, penalties range from $250 to $50,000. But if you're curious about the exact itemization of the penalty list, I encourage you to follow the link in the description and check out Ontario Regulation 289/01. Subsection 2 of Section 113 requires that the notice contains or is accompanied by information detailing the nature of the contravention. This helps ensure that the person receiving the notice understands the specific contravention being alleged. Subsection 3 mandates that the notice be served on the person in accordance with Section 95, ensuring proper delivery and acknowledgement of receipt. Subsection 4 was repealed in 2009 and is no longer in effect, so we're going to skip that one. Subsection 5 deems a person to have contravened the specified provision if they fail to apply for a review of the notice within the period set out in subsection 1, or if they apply for a review and the board finds a contravention. Subsection 6 of the Act addresses the penalties for persons deemed to have contravened the Act. This subsection specifies that a person who is deemed to have contravened the Act must pay the penalty for the deemed contravention. Additionally, they are responsible for paying any collector's fees and disbursements that have been added to the amount under subsection 2 of Section 128, which we'll get to later. This means that beyond the penalty for the contravention itself, the person is also liable for any additional costs incurred in the process of collecting the penalty, as outlined in subsection 2 of Section 128. These additional costs could include fees for collection services and related expenses. The requirement to pay both the penalty and these additional fees emphasizes the financial consequences of noncompliance with the Act. Subsection 6.1 of Section 113 of the Act specifically states that the penalty for a deemed contravention must be paid within 30 days after the day the notice of contravention was served. If the notice of contravention is appealed, then the payment must be made within 30 days after the board finds that there was a contravention. This precise time frame is crucial for compliance and provides a clear deadline for the payment of penalties. subsections 6.2 to 6.4 grant the director the authority to publicly disclose details of the deemed contravention, including the person's name, description of the contravention, date, and penalty. This disclosure can be made available to the general public, including publication on the internet, and is deemed compliant with the Freedom of Information and Protection of Privacy Act. Subsection 7 of Section 113 states that a notice of contravention can be issued even if an order has been or may be issued for the same contravention under other specified sections, or if the person has been or may be prosecuted for the same contravention. This allows for multiple avenues of enforcement and penalty for the same contravention. Subsections 8 and 9 specify that this section does not apply to contraventions regarding employees represented by a trade union or to contraventions by directors or officers of a corporation. In summary, Section 113 provides a mechanism for employment standards officers to issue notices of contravention, outlining the process for determining and imposing penalties and allowing for public disclosure of contraventions, while also clarifying situations where the section does not apply. Moving on to Section 114, this section establishes limitations on the time frame within which an employment standards officer can issue orders or notices related to contraventions of the Act. Subsection 1 of this section sets a 2-year limitation period for issuing an order to pay wages, fees, or compensation, or a notice of contravention concerning an employee. This limitation period is counted from different starting points depending on the situation, and they are listed A through C. Clause 1A says that if the employee filed a complaint about the contravention, then the limitation period is 2 years from the date the complaint was filed. Clause 1B says that if the employee did not file a complaint, but another employee of the same employer did, and the contravention was discovered during the investigation of that complaint, then the limitation period is 2 years from when the other employee's complaint was filed. Clause 1C says that if the employee did not file a complaint and Clause B does not apply, then the limitation period is 2 years from when an employment standards officer commenced an inspection of the employer to determine if a contravention occurred. Subsection 2 of Section 114 deals with situations where multiple employees file complaints about the same or substantially the same contravention. In such cases, the subsection is applied as if only the first employee filed the complaint. Subsection 3 provides an exception to Subsection 2. If an officer had already issued an order or advised of a refusal to issue an order regarding the earlier complaint before the subsequent complaint was filed, then Subsection 2 does not apply. Subsection 4 restricts the amendment or rescission of an order to pay wages, fees, or compensation after the last day on which the order could have been issued under subsection 1, unless both the employer against whom the order was issued and the employee consent to the amendment or rescission. Subsection 5 similarly restricts the power of an employment standards officer to amend or rescind a notice of contravention after the period in which they could have originally issued that notice, unless the employer who was issued the notice agrees to the change. In simpler terms, this means that once the deadline for issuing a notice of contravention has passed, an officer cannot change or cancel that notice unless the employer who received the notice agrees to those changes or cancellation. This rule ensures that notices of contravention are finalized and enforceable unless the affected employer consents to modify them. Subsection 6 modifies how this section applies for situations involving Part 18.1 of the ESA, which pertains to temporary help agencies and recruiters. This modification includes references to clients of temporary help agencies, recruiters, prospective employers, assignment employees, prospective assignment employees, and prospective employees engaged with recruiters. Like I mentioned before, we'll get into Part 18.1 of the ESA in another video. In summary, Section 114 establishes a 2-year limitation period for the issuance of orders and notices related to contraventions of the Act, with specific provisions for various scenarios and exceptions. This section ensures timely enforcement action and provides clarity on the period within which such actions must be taken. Moving on to Section 115, this section provides a definition for when contraventions are considered substantially the same, which is relevant for applying the limitations on enforcement actions in Section 114. Subsection 1 of this section explains that contraventions are considered substantially the same if they result in 2 employees becoming entitled to recover money under the Act due to the employer's failure to comply with the same or virtually identical provisions of the Act, the regulations, or their employment contracts. This means that if 2 employees are affected by the same type of violation under the same circumstances, their cases are considered substantially the same. Subsection 1.1 extends the application of this definition to situations involving Part 18.1 of the Act, which relates to temporary help agencies and recruiters. It modifies the references to include clients of temporary help agencies, recruiters, prospective employers, and various types of employees and prospective employees associated with these agencies and recruiters. Subsection 2 provides an exception to the definition of substantially the same. Specifically, contraventions are not considered substantially the same merely because two employees are entitled to recover money due to violations of Section 11 or 13 of the Act if those violations pertain to different provisions of the Act or the regulations or to different provisions in their employment contracts. This means that even if two employees are owed wages due to an employer's failure to comply with the Act, their cases might not be considered substantially the same if the specifics of their wage entitlements differ significantly. In simpler terms, substantially the same means that the violations affecting two employees are nearly identical in nature and circumstance. However, if the violations concern different aspects of wage payment or deductions, they might not be considered the same, even if both employees are owed money. So that brings us to the end of part 22 of the ESA, and we've got 3 parts left to go in this particular video. By this point in the video, you have an in-depth understanding of who enforces the ESA, what they can do, and how complaints are handled. Now let's move on to part 23, which deals with how orders are reviewed by the Ontario Labour Relations Board, or OLRB for short. The OLRB is an independent adjudicative tribunal issuing decisions based upon the evidence presented and submissions made to it by the parties and upon its interpretation and determination of the relevant legislation and jurisprudence. It plays a fundamental role in the labor relations regime in Ontario and encourages harmonious relations between employers, employees, and trade unions by dealing with matters before it as expeditiously and as fairly as reasonably possible. To kick off Part 23 of the ESA, Section 115.1 deals with the interpretation of the term employee within the context of this part of the ESA. It expands the traditional definition of an employee to include several other categories of workers who are often involved in less traditional or more flexible work arrangements. Specifically, the section states that whenever the term employee is used in this part of the ESA, it also refers to the following 3 types of employees. First, assignment employees, who are individuals who work for temporary help agencies and are assigned to perform work at and for the clients of these agencies. Second, prospective assignment employees, who are individuals who are seeking employment through a temporary help agency but have not yet been assigned to a client. And third, prospective employees who use the services of a recruiter, who are individuals who are seeking employment in Ontario and are using the services of a recruiter to find potential employment opportunities. This inclusion is significant because it ensures that the protections and provisions of the ESA are applied not only to traditional employees but also to those who are in less conventional employment situations. By doing so, the ESA acknowledges the evolving nature of the workforce and the various forms of employment relationships that exist in the modern workplace. This interpretation is especially relevant in the context of temporary help agencies and recruitment services, where the lines of traditional employment can be blurred. It ensures that workers in these categories are afforded the same rights and protections as other employees under the ESA. Since we're currently delving into the review processes by the Ontario Labour Relations Board, casting the net broadly to include as many people as possible is important because we're talking about how decisions and orders made under the ESA can be challenged or reviewed, ensuring that there are mechanisms for fair and just resolutions of disputes, which apply to a wide variety of employees. Moving on to Section 116, this section outlines the review process for orders issued under the Employment Standards Act. Essentially, if someone is subject to an order under specific sections like 74.14, 74.16, 74.17, 74.19, 103, 104, 106, 107, or 108, then they have the right to request a review by the Ontario Labour Relations Board. This request must be made within 30 days of the order being served, as specified in subsection 4. For orders involving payment, such as those under Section 74.14 or 103, the individual must either pay the owed amount into trust or provide an acceptable, irrevocable letter of credit, detailed in subsection 1. The same applies to orders under Sections 74.16, 74.17, 74.19, or 104, but with a cap of $10,000. Employees also have the right to request a review under subsection 2 if an order affects them. In contrast to the employers or other parties, employees aren't required to pay into trust to seek this review. Additionally, if an employee feels that an order should have been issued but wasn't, they can request a review of this refusal under subsection 3, again within the same 30-day window. The board has the authority to extend this time frame for applying for a review under specific circumstances outlined in subsection 5. A hearing is mandatory for these reviews, as mentioned in subsection 6, giving all parties a fair chance to present their case. The parties involved in the review process include the person who applied for the review, the employee concerned, concerned, the director, and potentially other individuals specified by the board, as noted in subsection 7. The board ensures that all parties have a complete opportunity to present their evidence and arguments, as described in subsection 8. Finally, the board itself determines its own practice and procedure for conducting these reviews, as per subsection 9. This section is key as it provides individuals and businesses with a formal avenue to challenge or seek clarification on orders issued under the Act, ensuring a balanced and equitable resolution process. Moving on to section 117, this section deals with the handling of money paid into trust with the director during the review process of an order. But what exactly does that mean? Let me explain. Subsection 1 of section 117 explains that this section applies when money related to an order to pay wages, fees, or compensation is held in trust by the director and the person against whom the order was made requests a review from the board. This establishes the context for the funds being held and the conditions under which this section is relevant. Subsection 2 mandates that the money held in trust must be kept in an interest-bearing account while the review application is pending. This is crucial for preserving the value of the funds during the review process. Subsection 3 addresses the scenario where a settlement is reached under section 112 or 120. In such cases, the money held in trust, along with the interest that has been accumulated, is to be dispersed according to the terms of the settlement. The interest is calculated based on the rate and method determined by the director, as stated in subsection 5 of section 88. Subsection 4 of section 117 deals with situations where no settlement is reached under section 112 or 120. Here, the trust funds are to be paid out in accordance with the board's decision, including interest calculated at the rate and method determined by the director under subsection 5 of section 88. This ensures that even if no settlement is reached, the money and its accrued interest are distributed fairly based on the board's decision. Through these subsections, section 117 provides a clear framework for managing and distributing funds held in trust during the review process, ensuring fairness and the preservation of value for all parties involved. Moving on to section 118, subsection 1 of this section states that the chair of the Ontario Labour Relations Board is empowered to establish rules regarding the board's practice and procedure, including how the board exercises its powers. This also includes the authority to specify the forms to be used in proceedings before the board. Subsection 2 states that the chair of the OLRB can also make rules to expedite decisions about the board's jurisdiction. These rules can stipulate that a full hearing isn't necessary and can even limit how much opportunity parties have to present evidence and make submissions. This is significant because it allows the OLRB to resolve certain matters more quickly, especially when the issue at hand is the board's jurisdiction to hear a case. Subsection 3 was repealed in 2018, meaning it is no longer in force or in effect, so we're going to skip this one. Subsection 4 says that in the event of any conflict between the rules established by the OLRB chair and the Statutory Powers Procedure Act, which governs the practice and procedure of most Ontario tribunals, then the rules made under this section of the ESA will take priority. You'll see that a lot in Ontario law and frankly in common law systems around the world, where laws can sometimes conflict with each other, so they always need to contain language that clarifies which one will take priority. I've personally never encountered a situation where two opposite laws say that they take priority over each other, but if it ever happens, I guess that's why we have courts. Continuing with section 118, subsection 5, says that the OLRB's rules are not considered regulations as defined in Part 3 of the Legislation Act. This distinction is important because it clarifies the legal status of these rules and their place within the broader legislative framework. You might have noticed in this video and in other videos on this channel that I often mention Ontario regulation followed by a number. By now, you've also probably noticed that these regulations have the power to modify and add clarity to sections and subsections of other legislation, such as the Employment Standards Act in this particular video series. With so many levels of laws and different rules interacting with each other, you end up with situations like this one at subsection 5 of section 118 that need to clarify the hierarchy of the regulatory system we live in. In my opinion, it does get a bit complicated to the point where most people aren't in a position to really understand it, but that's also why I enjoy making this content to help make the law accessible to everyone. Okay, enough ranting about my personal opinions. Let's move on to section 119. Subsection 1 of Section 119 sets out the board's powers in a review, as per Section 116. This part outlines the specific jurisdiction and authority the board has in reviewing orders under the ESA. Subsection 2 of Section 119 allows the board to designate one or more parties from a group with the same or substantially the same interest to represent the entire group. This simplifies the process when multiple parties are involved but share common objectives or concerns. Subsection 3 states that either the chair or a vice vice chair of the board is sufficient to form a quorum for the purposes of this section. Essentially, this means that either the chairperson or a vice chairperson of the OLRB alone is enough to conduct a review. This means that just one of these high-ranking officials on the board can make decisions and exercise the board's powers for the review process without needing the presence of other members. This provision is designed to streamline the review process, making it more efficient by allowing a single chairperson or vice chairperson to handle these matters. Subsection 4 grants the board the authority to require any person, regardless of their involvement in the review, to post notices as deemed appropriate by the board. Subsection 5 elaborates that if the board requires a person to post notices, they must do so in a conspicuous place or places where they are likely to be seen by those interested in the review. Subsection 6 gives the board the power to exercise the same authorities as an employment standards officer and to substitute its own findings for those of the officer who issued or refused the order. Subsection 7 specifically allows the board, on reviewing an order, to amend, rescind, affirm the order, or issue a new one. It can also issue an order or affirm a refusal when reviewing a refusal to issue an order. Here's what it means in simpler terms. When the board is reviewing an order made by an employment standards officer, they can either change the order, in other words, amend it, or they can cancel it, in other words, rescind it, or they can confirm it as is, in other words, they can affirm it, or they can decide to issue a completely new order. If they are reviewing a situation where an employment standards officer decided not to issue an order, the board can either agree with that decision, affirm the refusal, or they can go ahead and issue a new order themselves. Basically, this subsection empowers the board to thoroughly review and decide upon the actions taken by employment standards officers, ensuring that the final decision is fair and appropriate in each case. Subsection 8 enables the board to direct a labor relations officer to examine any records or documents and make any necessary inquiries after a review application is made. However, it shall not direct an employment standards officer to do so. Subsection 9 applies the provisions of sections 91 and 92 to labor relations officers acting under subsection 8, enabling them to conduct necessary inspections and investigations. I know I just threw a lot of section numbers at you, so here's what that means in simpler terms. Normally, under the Act, employment standards officers have the power to enter workplaces and inspect records to investigate potential violations of the Act, as described in sections 91 and 92. Subsection 9 of section 119 says that when a labor relations officer is working on a case as directed by the board, as mentioned in subsection 8 of section 119, they can use these same powers that employment standards officers typically have. This means a labor relations officer can enter and inspect workplaces, review records, and conduct investigations just like employment standards officers, but only when they are specifically assigned to do so by the board. In essence, this subsection allows labor relations officers to step into the shoes of employment standards officers for certain investigations, especially when directed by the board during a review process. Subsections 10 and 11 work in tandem to address situations during a review where it's clear that a specific amount of wages, fees, or compensation is owed to an employee. Subsection 10 of the ESA concerns situations during a review of an order requiring payment, like wages or compensation, by the board. It applies when either the board determines that a specific amount is definitely owed or there's no dispute about a certain amount being owed. Then subsection 11 comes into play. It requires the board to affirm the order for the amount that is clearly owed or issue a new order for that amount, even if the entire review process is not yet completed. This approach ensures that the part of the payment issue that is clear-cut and undisputed is resolved quickly without having to wait for the conclusion of the full review. Subsection 12 allows the Ontario Labour Relations Board to include interest payments in its decisions. This means when the board makes, amends, or confirms an order that requires someone to pay wages, fees, or compensation, they can also order that person to pay interest. The rate and method for calculating this interest are determined by the Director of Employment Standards, as outlined in subsection 5 of section 88 of the Act. Essentially, this subsection empowers the board to add interest charges to the amounts due, which can be an important factor in ensuring fairness, especially in cases where payments have been delayed. Subsection 13 states that decisions made by the board are final and binding on the involved parties and any others the board specifies. Subsection 14 clarifies that while subsection 13 establishes the finality of the board's decisions, these decisions can be reviewed by a court. This process is known as judicial review. In simpler terms, judicial review is a legal process in Canada where a court examines the decisions made by a tribunal, board, or administrative body, like the OLRB, to ensure they were made properly and fairly. During a judicial review, the court doesn't redo the entire decision-making process. Instead, it looks at whether the original decision was made in accordance with the law, followed proper procedures, and was reasonable. In the context of subsection 14, while the OLRB's decision is final in most cases, if someone believes that the decision was unreasonable or wasn't made properly, they can ask a court to review it. The court will then check if the OLRB's decision was reasonable and in line with the proper interpretation of the Employment Standards Act. If the court finds that the decision was unreasonable, it has the power to overturn it. This process ensures that the OLRB's decisions are fair and within the bounds of the law. Moving on to Section 120, subsections 1 and 2 state that the OLRB has the authority to assign a labor relations officer to help resolve issues that have led to an application for review under Section 116. This means that even after the review process has begun, or if the employment standards officer involved in the original order isn't part of the settlement discussions, the parties can still reach a settlement through the labor relations officer. Subsection 3 essentially says that any settlement agreement related to a compliance order must get approval from the director before it can be considered valid. This is to ensure that the terms of the settlement are appropriate and in line with the ESA. When a settlement is reached and the parties fulfill their agreed-upon obligations, subsection 4 explains that the settlement becomes binding. This also means that if the review was about an order, that order is nullified and the review process is concluded. However, if an employee involved in the settlement later shows that they agreed to the settlement terms due to fraud or coercion, subsection 5 provides a way for them to void the settlement. In such cases, if the review was concerning an order, that order will be reinstated and the review will continue. Lastly, subsection 6 addresses situations where the order under review required payment to be held in trust by the director. In these cases, the director is tasked with distributing the trust money according to the settlement terms. However, the director is still entitled to a portion of the administrative costs and any collector's fees or disbursements related to the order, proportional to the amount of wages, fees, or compensation that the employee receives under the settlement. Moving on to Section 121, this section deals with the referral of matters related to Part 13 to the OLRB. By the way, Part 13 of the ESA deals with benefit plans. Subsection 1 of Section 121 states that if the director believes that an employer, an organization of employers or employees, or someone acting on their behalf might have violated the laws regarding benefit plans, the director can refer this matter to the OLRB. Once a matter is referred to the OLRB, then subsection 2 says that the OLRB is required to hold a hearing. The purpose of this hearing is to determine whether there was indeed a contravention of Part 13 by the employer, organization, or representative. If the OLRB finds that there was a contravention, subsection 3 grants it the power to order the responsible party to stop the contravention and take necessary action to prevent further contraventions. Additionally, the OLRB can order the party to compensate any individual or group who might have suffered loss or disadvantage due to the contravention. Subsection 4 brings into play several procedural rules from other parts of the Act, applying them to proceedings under this section. These include rules related to reviews, the powers of the board, and settlements. Specifically, it references a wide variety of subsections contained inside sections 116, 118, 119, and 120, indicating that the same procedures and rights that apply in reviews, hearings, and settlements in other parts of the Act are also applicable to proceedings dealing with contraventions of benefit plans. Moving on to Section 122 of Ontario's Employment Standards Act, this section outlines the process for disputing a notice of contravention issued under Section 113. Subsection 1 of Section 122 provides the right to any person who has received a notice of contravention to apply for a review by the Ontario Labour Relations Board. This application must be made within 30 days of receiving the notice, or within an extended period if the OLRB deems it appropriate under special circumstances. Subsection 2 of this section requires the OLRB to conduct a hearing to review the notice of contravention. According to subsection 3, the parties involved in this review are the person against whom the notice was issued and the director. In these proceedings, as per subsection 4, the responsibility, or onus, to prove that the person did contravene the act, as indicated in the notice, lies with the director. This This must be established on a balance of probabilities, which is the standard of proof used in civil cases. In simpler terms, it means that when a person challenges a notice claiming they violated the act, it is up to the director, representing the authorities who issued the notice, to prove that the violation did indeed occur. This proof must be convincing enough to show that it's more likely than not that the contravention happened. This standard is known as the balance of probabilities, which is a common standard used in civil cases as opposed to the beyond a reasonable doubt standard used in criminal cases. Subsection 5 lays out the possible outcomes of the review. The board may find that the person did not contravene the provision and rescind the notice, affirm the notice if it finds a contravention did occur, or amend the notice by reducing the penalty if it finds a contravention but considers a lesser penalty appropriate. Subsection 6 deals with the addition of collector's fees and disbursements to the penalty amount. Before making its decision, the board must inquire whether these additional costs have been added. If they have, the board must inform the person of the total amount due, including these additional costs. Finally, subsection 7 states that various provisions from sections 116, 118, and 119 apply to the review process under section 122. This includes rules regarding practice and procedure, quorum, and the finality of the board's decisions, among other things. These provisions are adapted as necessary to fit the context of reviewing a notice of contravention. Moving on to 123, subsection 1 of this section specifies that certain individuals connected to the OLRB cannot be forced to testify in civil proceedings or in front of the board or other tribunals about information they learned while doing their duties under the Act. This protection applies to board members, the board's registrar, and employees of the board. Essentially, this means these individuals have a kind of privilege that prevents them from being required to share information they've come across through their official roles unless the board itself agrees. Subsection 2 imposes a confidentiality obligation on labor relations officers who handle information or materials under the Act. They are not allowed to disclose this information to anyone other than the board, unless specifically authorized by the board to do so. This ensures that sensitive information gathered during the course of their duties is kept confidential. Moving on to section 124, this section deals with the scenario where the board has begun a hearing to review an order, a refusal to issue an order, or a notice of contravention, but has not made a decision 6 months after the hearing's last day. Subsection 1 simply describes the situation I just mentioned. Subsection 2 allows a party involved in the proceeding to request the chair of the board to terminate the proceeding if such a delay occurs. Finally, subsection 3 states that if a proceeding is terminated due to this delay, the chair of the board must restart the proceeding with terms and conditions deemed appropriate. This section aims to address potential delays in the decision-making process, ensuring fairness and efficiency in the handling of cases. So that brings us to the end of part 23 of the ESA, and we've got 2 parts left to go. If you've made it this far in the video, I want to say that I'm really proud of you. The content that you're learning is not simple stuff, and the overwhelming majority of people in Ontario, unfortunately, don't have a clear understanding of how all these laws work, mostly because nobody ever explained it to them. But that's not going to be you. So let's move on to part 24, which deals with how collections work under the ESA's enforcement laws. Moving on to section 125 of the Employment Standards Act. Subsection 1 of this section empowers the director to demand payment from third parties who owe or will owe money to an employer, director, or other person liable for a payment under the Act. This demand can be made if the director believes or suspects that the third party is in possession of funds that should be directed towards settling a liability under the Act. For example, if a company owes wages to its employees under the Act and the director suspects another entity owes money to this company, the director can demand that the entity pays what it owes directly to the director in trust instead of to the company. Subsection 1.1 of Section 125 specifies that such a demand remains effective for 365 days from the date it's served. This means the third party is obligated to comply with the demand for a year from the notice date. Subsection 2 clarifies that the general rule in subsection 1 also applies to clients of temporary help agencies. If a client owes money to such an agency, the director can demand that the client pays the director instead to cover liabilities of the agency under the Act. Subsection 3 requires that the director must serve notice of the demand to the person from whom payment is being demanded, as per the service rules outlined in Section 95. Subsection 4 provides that when a third party complies with such a demand and pays the director, they are discharged from liability to the extent of that payment. This means they won't owe the original amount to the employer, director, or other person anymore. Finally, subsection 5 establishes that if a third party pays the employer, director, or other person after receiving a demand from the director but doesn't comply with the demand, they must pay the director the lesser of the amount they paid or the amount demanded. This ensures that the third party cannot evade their obligation under the demand by paying the original debtor instead. Moving on to section 125.1, this section grants the director the discretion to accept any form of security deemed satisfactory for the payment of amounts owed under the Act. This means if an employer or other person has a financial obligation under the Act, like unpaid wages, the director can agree to accept collateral or a guarantee to ensure that the debt will be paid. This could include things like a bond, a mortgage, or any other asset or agreement that the director finds acceptable as a guarantee of payment. Moving on to section 125.2, this section explains that the director has the authority to issue a warrant to enforce the payment of amounts due under an order made under the Act. This warrant is directed to the sheriff of the area where the debtor's property is located. Essentially, it allows the sheriff to seize and sell the debtor's property to satisfy the debt. The amounts enforced by the warrant include the sums specified in the order along with any applicable interest, and the costs and expenses incurred by the sheriff in executing the warrant. This warrant is as powerful and effective as a writ of execution from the Superior Court of Justice, which is commonly used in civil cases to enforce judgments for the payment of money. As a side note, I plan to make a lot of exciting videos about how civil lawsuits work in court and the enforcement processes that are involved there. Depending on when you're watching this video, that content might have already been published. Moving on to section 125.3, subsection 1 of this section establishes that when an order to pay money is made under the ESA, the amount owed, including any interest, can become a lien and charge on any real property the employer, director, or other responsible person owns. This lien takes effect when the director registers a notice in the land registry office. Essentially, this creates a legal claim on the property as security for the debt owed. Subsection 2 extends this concept to personal property. Upon registration of a notice with the registrar under the Personal Property Security Act, any personal property owned or later acquired by the debtor in Ontario becomes subject to a lien and charge for the amount owed under the Act, including interest. Subsection 3 clarifies that the lien and charge cover all amounts owed at the time of registration and any future liabilities while the notice remains registered. This takes priority over any later registered or acquired security interests, encumbrances, or claims against the debtor's property. Okay, so I know I just threw a lot of technical legal terms at you, which some of you may already be familiar with, and some might be left scratching your heads wondering what these terms mean. So let's take a pause for a moment. A lien is like a legal claim or hold on someone's property. Imagine if someone owes you money, and to ensure they pay you back, you get a legal right to hold on to something valuable they own, like a car or house, until they pay up. That's essentially what a lien does. If they don't pay, you might have the right to sell that item to get your money back. In legal terms, a charge is similar to a lien. It's a form of security for a debt. For example, if a business takes out a loan, the lender might put a charge on the business's property. This means that if the business doesn't repay the loan, the lender has a claim on that property. Regarding the word encumbrance, this term is a bit broader. An encumbrance is anything that limits the use or reduces the value of property. It's not just about debts. For instance, if there's a legal restriction that says a piece of land can't be used for certain types of construction, that's an encumbrance. Liens and charges are types of encumbrances because they also limit what you can do with your property since someone else has a claim on it. Lastly, a security interest is a legal right or interest that a creditor has in the debtor's property, given to secure a loan or other obligation. It's a bit like taking collateral. For example, when you get a car loan, the lender has a security interest in your car. If you don't pay the loan, they can take the car. It's their security that ensures they get paid one way or another. In essence, all these terms are related to the rights and claims that can be placed on property, either as a way to ensure debts are paid or to acknowledge that there are limits on how a property can be used or accessed. Now that you've got a solid understanding of those definitions, the rest of section 125.3 will probably make a lot more sense. Continuing with subsection 4 of subsection 125.3, this subsection notes an exception. The lien under subsection 2 does not take priority over a perfected purchase money security interest in collateral or proceeds and is considered a security interest for priority rules under the Personal Property Security Act. I know what you're thinking. Great. Thanks for giving me more legal jargon, Ryan. Okay, let's unpack this for a moment. Essentially, subsection 4 is about when a lien on property doesn't have as much power as another type of lien known as a perfected purchase money security interest. When a lien is placed on personal property, like a car or equipment, under this act, because someone owes money, it usually gets a sort of first claim on the property. This means if the property is sold, the money from the sale first goes to pay off this lien. However, there's an exception. If there's already a perfected purchase money security interest on that property, this type of interest gets priority over the lien from this act. So, what's a perfected purchase money security interest? It's a special kind of security interest on property that someone buys. For example, if you buy a car on a finance plan, the finance company might have a perfected purchase money security interest in your car. This means they have a claim on the car until you pay off your loan in full. So, subsection 4 is saying that even though the lien from this act is powerful, it doesn't outrank a perfected purchase money security interest. In other words, if someone owes money under this act and their property is sold to pay off debts, the money from the sale would first go to settle any perfected purchase money security interests before addressing the lien from this act. Continuing with subsection 5, this subsection states that a lien notice under subsection 2 is effective from its registration time and expires after 5 years unless renewed. If renewed, the lien continues for another 5 years from the renewal date. Subsection 6 allows the director to renew the notice of lien and charge for additional 5-year periods until the owed amount is fully paid, maintaining continuous registration from the initial registration date. Subsection 7 addresses cases where the debtor has an interest in real property but is not the registered owner. The notice under subsection 1 must state the debtor's interest in the property, and a copy must be sent to the registered owner's address as listed in the latest notice of assessment under the Assessment Act. Subsection 8 gives the director rights and remedies equivalent to those of a secured party under various sections of the Personal Property Security Act and other related acts, applicable to the lien under subsection 2. If you're not familiar with the term secured party, let me explain. Subsection 8 is basically defining the legal powers and rights the director has when there's a lien on personal property due to unpaid amounts under the act. The director is treated like a secured party under certain sections of the Personal Property Security Act. This means the director has certain legal rights and powers over the personal property that has the lien on it, similar to those held by a creditor who has a security interest in the property, like a bank that has a lien on a car because of an unpaid loan. The director's lien is considered a security interest. This is important because it defines the director's legal rights over the property, especially when it comes to enforcing the lien, like seizing or selling the property to recover the owed money. The director also has the same rights as someone holding a security interest under the Repair and Storage Liens Act. This means if the personal property is an item like a car or equipment that can be stored or repaired, the director has certain rights to ensure the recovery of the amount, such as retaining possession of the item until the debt is paid. In summary, Subsection 8 gives the director similar powers to those of a creditor who has a security interest in someone's personal property. These powers help the director enforce liens and recover owed amounts under the Act. Subsection 9 requires the notice of lien and charge or its renewal to be in the form of a financing statement or a financing change statement as prescribed, and it can be registered under Part 4 of the Personal Property Security Act or mailed to a prescribed address. Subsection 10 clarifies that errors or omissions in the notice of lien and charge or its execution or registration do not invalidate the notice or impair its effect unless it would materially mislead a reasonable person. Subsection 11 of Section 125.3 addresses how the liens and charges mentioned in the section interact with the Federal Bankruptcy and Insolvency Act in Canada. This subsection acknowledges that the rights and rules under the Bankruptcy and Insolvency Act in Canada are not affected or changed by the liens and charges created under the Employment Standards Act. The Bankruptcy and Insolvency Act is a federal law that outlines what happens when a person or company can't pay their debts. It includes rules for bankruptcy and restructuring processes. When a person or company goes bankrupt, the Bankruptcy and Insolvency Act sets out specific rules about how their debts are handled, who gets paid first, and so forth. Subsection 11 clarifies that even if there's a lien or charge on someone's property under the Employment Standards Act, the process and rules set out in the federal bankruptcy law still apply. This means that when dealing with bankruptcy cases, the federal law takes precedence over the liens and charges under the Provincial Employment Standards Act. In essence, subsection 11 ensures that the provincial regulations about recovering owed money through liens don't override or interfere with the federal bankruptcy processes. Subsection 12 defines real property for this section's purposes, including fixtures and any person's interest as a lessee of real property. But what does that mean in plain English? The term real property refers to land and anything permanently attached to it, like buildings or houses. It also includes fixtures, which are items that are attached to a building or land in a way that makes them a permanent permanent part of the property, like built-in cabinets or a furnace. The phrase interest of a person as lessee of real property means that if a person is leasing, meaning renting real property, their rights or interests as a tenant are included in the definition of real property. For instance, if a company rents a warehouse, the leasehold interest, their rights under the lease agreement, is considered real property for the purposes of this section. In summary, subsection 12 defines real property to include not just land and buildings, but also any fixtures and leasehold interests. This definition is important because the section is about placing liens and charges on real property when someone owes money under the Act. Understanding what is included in real property helps clarify what can be subject to a lien or charge. Moving on to Section 126, subsection 1 of this section allows the director to file a certified copy of an order to pay money made under the Act in a court that has the authority to handle such cases. This step is taken to ensure the order is recognized and can be enforced legally. Subsection 2 of Section 126 requires the director to inform the person against whom the order was made about the filing of the order in court. This is done by serving a letter to that person as per the procedure outlined in Section 95 of the Act. Subsection 3 of Section 126 states that once an order is filed in court, the director can enforce it in the same way a court's judgment or order is enforced. This means the order has the same legal power as a court decision, making it easier for the director to ensure compliance. Lastly, subsection 4 extends these provisions to notices of contravention. This means that a notice of contravention, which is a formal notification of a violation of the Act, can also be filed in court and enforced as a court judgment or order. Basically, these subsections allow the director to take an order or notice from the Employment Standards Act, file it with a court, and then enforce it as if it were a court order or judgment, ensuring compliance with the Act. Moving on to Section 127, subsection 1 of this section permits the director to delegate specific powers to a collector. This delegation is for the purpose of collecting amounts owed under the Act or under an order from a reciprocating state, as referenced in Section 130. Subsection 2 allows the director to specify certain powers in the authorization given to the collector. These powers can include those under Sections 125, 125.1, 125.2, 125.3, 126, and 130, as well as subsection 3 of Section 135 of the Act, and the board's powers under Section 19 of the Statutory Powers Procedure Act. I know that we haven't gotten to all of those sections yet, but we'll get around to those sections later in this video. Under subsection 3, the director can authorize the collector to collect fees or disbursements, or both, from people who owe money under the Act. This is an exception to one of the laws in Ontario's Collection and Debt Settlement Services Act, which usually restricts such collections. In simpler terms, this subsection gives the director the authority to let collectors add a reasonable charge to the debt they are collecting to cover their collection costs. This means if someone owes money under the Employment Standards Act, they might have to pay not just the owed amount, but also an additional fee for the cost of collecting that debt. Subsection 4 gives the director the authority to set conditions on the authorization given to collectors, and to determine what constitutes reasonable fees or disbursements. Subsection 5 specifies that collectors who are required to register under the Collection and Debt Settlement Services Act cannot be authorized to collect disbursements. Disbursements are the expenses incurred by the collector in the process of collecting debts. In simpler terms, this subsection means that if a debt collector is required to be officially registered under a specific act, the Collection and Debt Settlement Services Act, then the Director of Employment Standards cannot allow them to charge extra for their expenses or disbursements when they're collecting debts under the Employment Standards Act. This is a restriction placed on registered collectors to prevent them from adding additional costs to the amount already owed by the debtor. Subsection 6 allows the director to disclose or permit the disclosure of information collected under the Act to a collector. This is for the purpose of collecting amounts payable under the Act. Lastly, subsection 7 states that any disclosure of personal information made under subsection 6 is considered compliant with the Freedom of Information and Protection of Privacy Act. In summary, these subsections give the director the power to assign a collector to gather money owed under the Employment Standards Act. The director can specify which powers the collector can use, allow the collector to charge fees, and permit the sharing of necessary information with the collector to facilitate collection. Moving on to Section 128, subsection 1 allows a collector to use any of the powers that have been specifically granted to them in the authorization provided by the director under Section 127. This means that the collector can perform actions specified in their authorization to collect debts under the Act. Subsection 2 states that any fees and expenses authorized used under subsection 3 of section 127 for collecting an amount due under an order or notice of contravention are considered part of the amount owed in the order or notice. In simpler terms, the extra costs incurred by the collector for collecting the debt are added to the total amount of the debt. Subsection 3 outlines how a collector must distribute the money they collect. It specifies that any money collected for wages, fees, or compensation must be paid to the director in trust or directly to the entitled person with the director's written consent. Money collected for administrative costs must be paid to the director, while amounts collected for notices of contravention go to the Minister of Finance. The collector can retain any amount collected for their fees and disbursements. Subsection 4 deals with situations where the collected amount is less than the total amount owed. In such cases, the money is to be divided proportionally among all those owed money, including the director and the collector, and then distributed accordingly. Subsections 5 and 6 of Section 128 permit a collector to share information with the director that was gathered under the authority of the Act or regulations for collecting a payable amount under the Act. Any personal information shared in this process is considered to be in compliance with specific clauses of the Freedom of Information and Protection of Privacy Act. Moving on to Section 129, subsection 1 of this section allows a collector to settle with the person from whom they are trying to collect money. However, such a settlement requires written agreement from either the person to whom the money is owed or, in cases of a notice of contravention, from the director. Subsection 2 places a restriction on settlements. If the settlement means the person to whom the money is owed receives less than 75% of what they are entitled to, or a different percentage if prescribed, the collector must have the director's written approval for the settlement. Subsection 3 relates to situations where an order to pay money has been made under specific sections of the Act. If a settlement is reached under this section for the money owed, the original order is considered void and the settlement becomes binding. This holds true as long as the person against whom the order was issued fulfills their part of the settlement agreement. However, the settlement can be challenged on the grounds of fraud or coercion if the individual to whom the money was ordered to be paid applies to the board. Subsection 4 states that if a settlement is made regarding money owed under a notice of contravention, the notice becomes void once the person against whom it was issued fulfills their part of the settlement agreement. Subsection 5 dictates the payment process. The person who owes money under a settlement must pay the agreed amount to the collector. The collector is then responsible for distributing this money in accordance with Section 128 of the Act. Moving on to Section 130, subsection 1 of this section defines two key terms. First, the term order is used broadly and includes judgments. In the context of states with employment standards legislation similar to Ontario's, it also encompasses a certificate of an order for the payment of money under that legislation. Second, the term state is used to refer to other provinces or territories in Canada, foreign states, and political subdivisions of such states. Subsection 2 of Section 130 establishes that the states specified in the regulations are reciprocating states for the purposes of this section. It also identifies the authorities in these states that are authorized to make applications under this section. Like I mentioned earlier in this video, you can check out the link to Ontario Regulation 289/01 in the description of this video to take a look at the list of reciprocating states. But let's get into what this section is actually trying to do and move on from its definitions. Subsection 3 of Section 130 allows the designated authority of a reciprocating state to apply to the director for the enforcement of an order for the payment of money issued under that state's employment standards legislation. Subsection 4 requires that applications for enforcement be accompanied by a certified true copy of the order. The certification can be done either by the court where the order was filed, if the legislation of the reciprocating state allows for such filing, or by the designated authority if it does not. If that sounded like legal jargon that wasn't super clear, let me explain. Subsection 4 is all about how the designated authority from another province, territory, or country, collectively known as reciprocating states, must submit their request for enforcement of an employment-related financial order in Ontario. When this authority wants Ontario's help to enforce an order for payment of money, like unpaid wages, they need to provide a certified copy of the order along with their application. This copy must be certified as true either by the court, where the order was made, if that's allowed in their laws, or by the authority themselves if their laws don't require court involvement. In simpler terms, this means that when an official body from another place asks Ontario to help collect money based on their local employment laws, they must include an officially verified copy of the order for payment with their request. This ensures that the order is legitimate and correctly reflects what was decided in their jurisdiction. Subsection 5 of Section 130 gives the director the power to file a copy of the order in an Ontario court, making it enforceable as if it were a court judgment or order. This enforcement can be initiated either by the director or by the designated authority of the reciprocating state. Subsection 6 stipulates that the director or the designated authority is entitled to the costs of enforcing the order as if it were an order of the Ontario court where it was filed. These costs can be recovered in the same manner as sums payable under such a court order. So that brings us to the end of part 24, and we've only got one part left to go. Part 25 deals with the topic of offenses and prosecution, because what would the law be without consequences for bad behavior? All right, everyone, let's finish strong. To kick off part 25, section 131 deals with the illegality of falsifying records and providing false information, which are considered offenses under the Act. Subsection 1 makes it clear that it's illegal for anyone to create, maintain, or present false records or documents that are supposed to be kept in accordance with the Act. This prohibition extends to being involved in or tacitly agreeing to the creation and handling of such false records or documents. In simpler terms, this means that all records or documents that the law requires to be maintained must be accurate and true, and anyone involved in their management cannot engage in deceitful practices. Subsection 2 states that no one should provide false or misleading information when dealing with matters under this Act. This means that when you're required to provide information under the Employment Standards Act, such as during an investigation or compliance check, the information you give must be true and not intended to deceive. These provisions underscore the importance of honesty and accuracy in maintaining employment records and communicating under the Act, reflecting the law's commitment to fair and transparent employment practices. Moving on to section 132, this section outlines the general penalties for violating the Act or its regulations, or for failing to comply with an order or requirement under the Act. These penalties are listed A through C under Clause A of section 132. If an individual is found guilty of contravening the Act or regulations, they could face a fine of up to $50,000, imprisonment for up to 12 months, or both. This means that individual offenders can face significant financial penalties and possibly jail time for serious violations. Under Clause B of Section 132, this clause states that corporations found guilty of an offense can be fined up to $100,000. This highlights the higher financial penalty for corporate entities, reflecting their larger scale and resources. Finally, under Clause C of Section 132, this clause increases the fines for corporations with prior convictions under the Act. If a corporation has one previous conviction, the fine can be as high as $250,000. If the corporation has more than one prior conviction, the fine can go up to $500,000. This tiered penalty system is designed to impose stiffer penalties on repeat offenders, emphasizing the importance of ongoing compliance with the Act. Moving on to Section 133, this section provides additional orders a court can impose if an employer, client, or recruiter is convicted of certain offenses under the Act. Subsection 1 of Section 133 specifies that if an employer is convicted of contravening specific sections related to employee rights, such as Section 74, which deals with situations where employers retaliate against an employee for exercising their rights, or parts of subsection 1 of Section 74.8, or if a client or recruiter is convicted of contravening sections 74.12 or 74.12.1, then the court must order the convicted party to take specific actions to rectify the violation. This is in addition to any fines or imprisonment imposed. Essentially, the court is mandated to order corrective actions to remedy the harm caused by the contravention. I want to take a quick pause here for a moment and mention that even though Section 74 isn't discussed in this video, I will be making another video about that section because it is a pretty commonly used section, and it involves fairly stressful experiences that people go through in Ontario. As I mentioned, Section 74 deals with when an employer retaliates against an employee because the employee exercised their rights, and I'm sure you can imagine that those types of situations can get pretty ugly. For the purposes of our discussion right now, it's enough that you understand that the law takes these matters seriously, and as you can see in this subsection 1 of Section 133, there is a framework here to ensure that there are consequences for this type of behavior. Subsection 2 elaborates on what these court orders imposing consequences can include. 1. The payment of wages. If wages are owed to an individual, the court can order the convicted party to pay these wages. 2. Reinstatement. In cases involving contraventions of Section 74 or 74.12, the court can order that a person be reinstated to their job. And 3. Compensation for losses. The court can order the convicted party to compensate an individual for any losses they incurred due to the violation. Finally, subsection 3 deals specifically with contraventions related to lie detectors, which is found in Part 16 of the Act. If the contravention affected a job applicant, including those applying to be police officers, the court may order the employer to hire the applicant, compensate them, or both. This reflects the serious nature of misusing lie detectors in employment contexts and provides a way to address the specific harm done to job applicants in these scenarios. Moving on to Section 134, this section outlines the penalties for failing to comply with an order issued under Section 133. This section particularly addresses non-compliance with orders for reinstatement of an employee. The penalties are as follows. If the person is an individual, like a business owner or manager, they can be fined up to $2,000 for each day they continue to fail to comply with the reinstatement order. Additionally, they could face imprisonment for up to 6 months. They may be subject to both the fine and imprisonment. If the non-compliant entity is a corporation, it can be fined up to $4,000 for each day of continued non-compliance with the reinstatement order. These penalties underscore the seriousness with which the law views the obligation to follow court orders, particularly those related to reinstating employees. The per-day fines aim to provide a strong incentive for prompt compliance with reinstatement orders, emphasizing the importance of adhering to fair employment practices as laid out in the Act. Moving on to Section 135, subsection 1 states that if an employer is found guilty of breaking any part of the Employment Standards Act, other than specific sections in Section 74 or certain subsections of 74.8, then the court must not only impose fines or imprisonment, but also calculate any money owed to employees impacted by this violation. The court then orders the employer to pay these calculated amounts to the Director of Employment Standards. Subsection 2 assigns the responsibility of collecting the court-ordered amount to the director. Once collected, the director is tasked with distributing this amount to the employees who suffered due to the employer's violation. Subsection 3 allows the director to file the court's order in a court that has appropriate jurisdiction, effectively making it an enforceable court order. This action ensures that the order to pay the assessed amounts has legal support for enforcement, guaranteeing that the affected employees receive what they are owed. Each subsection within Section 135 works together to ensure that employees harmed by an employer's failure to adhere to the Act receive compensation and that the employer faces the necessary legal consequences. Moving on to Section 136, subsection 1 of this section outlines that a director of a corporation can be legally charged if they fail to adhere to an order from an employment standards officer as mentioned in Sections 106 or 107, particularly when they haven't sought a review of that order. Additionally, if such an order is modified or confirmed by the board upon review under Section 116, or if a new order is issued and the director still does not comply, they are considered to have committed an offense. In the context of Ontario corporate law, a director is an individual elected or appointed to oversee the activities and manage the affairs of a corporation. Directors play a critical role in making key decisions and ensuring the company adheres to legal and ethical standards. Subsection 2 details the consequences for a director who is found guilty of an offense as per subsection 1. The penalty is a fine of up to $50,000. This substantial fine is imposed to discourage negligence and enforce compliance with the legal responsibilities of directors concerning employment standards within their corporation. Moving on to Section 137, subsection 1 of this section specifies that if a corporation violates this act or its regulations, any officer, director, or agent of the corporation, or anyone acting in such a capacity who authorizes, permits, or passively accepts the violation is legally responsible. They are considered a party to the offense and, upon conviction, face the same penalties as the corporation, including fines or imprisonment. Subsection 2 of Section 137 clarifies that the liability of these individuals is independent of whether the corporation itself has been prosecuted or convicted for the offense. Subsection 3 places the burden of proof on the individual being prosecuted. It is up to them to demonstrate that they did not authorize, permit, or acquiesce in the corporation's contravention of the Act. This subsection essentially reverses the usual burden of proof in legal cases. In most legal situations, it's up to the prosecution to prove someone's guilt. However, under this subsection, if an individual, like an officer, director, or agent of a corporation, is charged with allowing the corporation to violate the Act, it's up to that individual to prove that they did not allow or or agree to the violation. They must demonstrate that they neither authorized, permitted, nor passively accepted the corporation's contravention of the act. This shift in the burden of proof means that the individual must actively provide evidence or arguments to show their innocence in this regard, rather than the prosecutor having to prove their guilt. Subsection 4 states that in addition to any fine or imprisonment imposed, the court can order the convicted individual to pay any outstanding amounts owed to employees affected by the violation. This payment is to be made to the director. Subsection 5 explains that the director is responsible for attempting to collect the assessed amount. If successful, the director distributes the collected amount to the affected employee. Subsection 6 ensures that no prosecution under this section begins without the explicit consent of the director. Finally, subsection 7 indicates that presenting a document that seems to show the director's consent to prosecute is sufficient evidence of such consent in legal proceedings. Moving on to section 137.1, subsection 1 of this section specifies that an employment standards officer cannot be prosecuted for an alleged violation of subsection 2 of section 89 of the ESA without the explicit consent of the Deputy Attorney General. Subsection 2 of section 89 requires employment standards officers to follow any policies established by the director under subsection 2 of section 88 of the Act. Essentially, this subsection provides a layer of legal protection for employment standards officers, ensuring that any legal action against them for not following these policies cannot proceed without the approval of a high-ranking legal official. Further, subsection 2 of section 137.1 outlines that showing a document which seems to indicate the Deputy Attorney General's consent for prosecuting an employment standards officer is sufficient evidence of such consent in legal proceedings. This means that in a court case where the issue of whether the Deputy Attorney General consented to the prosecution arises, simply producing a document that looks like it carries this consent is enough to prove it. Moving on to section 137, subsection 1 of this section allows for flexibility in determining where a trial for an offense under this act can take place. Usually, under Section 29 of the Provincial Offences Act, such prosecutions are held in a specific jurisdiction, typically where the offense occurred. However, subsection 1 of Section 138 provides an alternative. The prosecution can opt to have the trial in the Ontario Court of Justice, located where the accused person lives or conducts business. This means that if a business or individual is charged with an offense under the Employment Standards Act, the trial can be held in a court near their residence or business location if the prosecutor chooses this option. Subsection 2 of Section 138 gives the Attorney General or their representative the power to decide that a judge, rather than a justice of the peace, will hear and determine the case. This is done by submitting a notice to the clerk of the court. This provision is significant as it allows for the involvement of a judge, who typically has more legal expertise and experience in cases that might be complex or particularly important. Moreover, and you might not necessarily be aware of the following, but surprisingly, you don't have to have a law degree or have any experience practicing as a lawyer to be a justice of the peace in Ontario. As you can imagine, there may be situations where the case would naturally invite the involvement of a judge who does have that kind of legal experience rather than a justice of the peace. Moving on to section 138.1, subsection 1 of this section grants the Director of Employment Standards the authority to publicly disclose information about a person's conviction under this act. This includes revealing the convicted person's name, detailing the nature of the offense, mentioning the conviction date, and specifying the sentence imposed. This provision applies to all persons, including individuals, highlighting the Act's commitment to transparency and public awareness about violations of employment standards. Subsection 2 of Section 138.1 specifically includes the right to publish this information on the internet. This broadens the reach of such disclosures, allowing the general public easy access to information about convictions under the Employment Standards Act. Internet publication is a powerful tool for maintaining public awareness and can serve as a deterrent against future offenses. Subsection 3 of Section 138.1 clarifies that any disclosure made under subsection 1 of Section 138.1 is considered compliant with Clause E of subsection 1 of Section 42 of the Freedom of Information and Protection of Privacy Act. This means that the publication of a person's conviction details, as outlined in subsections 1 and 2 of Section 138.1, is legally permitted and does not violate privacy regulations. This provision ensures that the public's right to know about convictions under the Act is balanced with the legal framework governing privacy and information disclosure. Moving on to Section 139, this section sets a 2-year limitation period period for initiating prosecutions for offenses under the Act. This means that legal action for any alleged offense cannot begin more than 2 years after the date the offense is said to have occurred. This provision establishes a clear time frame within which the authorities must act to enforce the standards outlined in the Act, ensuring that potential offenses are addressed in a timely manner and providing a degree of certainty for both employers and employees. The limitation period helps to balance the need for effective enforcement of employment standards with the principle of fairness, ensuring that potential legal actions are not indefinitely delayed. That's a wrap on our deep dive into the enforcement mechanisms of Ontario's Employment Standards Act. We've covered a lot of ground spanning from Part 21 to Part 25, which included sections 84 to 139 of the ESA. It's been a comprehensive journey through the rules, regulations, and real-life implications of the ESA, and I hope it's been as enlightening for you as it has been for me. My name is Ryan Keeney, and I'm an Ontario lawyer passionate about making complex legal topics more accessible and understandable. If you've made it this far, thank you for sticking with me through this lengthy exploration. I know this video was a marathon, not a sprint, so I truly appreciate your time and attention. If you found this content helpful, please don't forget to hit that like button. It really supports the channel. Your comments are always welcome. They help me understand what you're interested in and how I can make my content even more useful for you. And of course, if you haven't already, please subscribe to the channel. That way you won't miss out on any future videos where I break down legal concepts in an easy to understand way. Remember, knowledge is power, especially when it comes to navigating the legal landscape. So stay informed, stay engaged, and I'll see you in the next video. Take care.